Well, hello everyone, and welcome to Uncivil Law. I hope everyone is having a great day. I'm having a great day. For today's live stream, we are going to be doing a read and discussion of a recent district court opinion from the district judge of the Southern District of California within the Ninth Circuit, Judge Benitez, who has written a wonderfully beautiful, scathing opinion that has destroyed California's assault weapon ban and the AR-15 ban and made them sorry they ever conceived of such a concept. It is 94 pages of legal mockery and derision, which of course I appreciate on many levels. And we're going to read this, and we're going to discuss it, and we're going to enjoy it, because we should. So get a drink of choice and help join me. So just before we start in the actual decision, of course, I'll just state the obvious. This is a decision from the district level of the Ninth Circuit, which means, of course, this will be appealed. So this decision may not legally be long for this world, but in some ways that is less important than it exists. Because law, if nothing, works by, if someone else did it first, it makes it easier for someone else to do it. So even if this opinion itself does not survive long for this world, because of someone like Judge Benitez, who lays it all out, it makes it easier for some other judge in some other circuit to borrow, lift, steal the concepts that are here and to move the law forward. So it is as important for its, actually it's more important for its laying things out than its actual underlying holding. The rationale and explanation is actually probably more important than the holding itself. So we're going to, not that the holding's not important, but we learn through the misfortunes of others, or in this case, we learn through the beauty of opinions, such as that written by based Judge Benitez. So we're going to read his 94 pages of beating California to death, which he has to beat them to death because, up until the second, the AR-15 was illegal, so he couldn't shoot them. So bludgeoning. So we're going to read this and enjoy. It should be fun. Introduction. Like the Swiss Army knife, and we know right away we're off to a good start, the popular AR-15 rifle is a perfect combination of home defense weapon and homeland defense equipment. Good for the home and battle, the AR-15 is the kind of versatile gun that lies at the intersection of kinds of firearms protected under Heller and Miller. Yet the state of California makes it a crime to have an AR-15, therefore the court declares the California statutes to be unconstitutional. Well, we're not really hiding the ball at all, are we? We're just, yep. Plaintiffs challenge a net of interlocutory statutes, which impose strict criminal restrictions on firearms that fall under California's complex definition of ignominious assault weapons. Hearings on preliminary injunctions were consolidated with the trial on the merits. So we did preliminary injunction, temporary injunction, merits all in one. So this is a final judgment. Having considered the evidence, the court issues these findings of facts and conclusions of law, finds for the plaintiffs, and enters a judgment accordingly. The Second Amendment elevates above all other interests the right of law-abiding, responsible citizens to use arms in defense of hearth and home. So saith Heller. Because, of course, as always, much like the Fourth Amendment, as well in the Second Amendment, the home is special. The Supreme Court clearly holds the Second Amendment protects guns commonly owned by law-abiding citizens for lawful purposes. At the same time, the Second Amendment confers an individual right, to keep and bear arms that have some reasonable relationship to the preservation or efficiency of a well-regulated militia. Any relationship will be fine. Although the Supreme Court has cautioned, the Second Amendment does not guarantee a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. In other words, like every other amendment, you can't just do anything all the time. You have to have a little bit more nuanced understanding. You could just rewrite this in First Amendment language and it would be exactly the same. So if you rewrote this in First Amendment language, you could say, although the Supreme Court has cautioned in the First Amendment does not guarantee the right to say any words whatsoever in any manner and whatever purpose. It would be equally true, right? First Amendment or Second Amendment. Because the lower courts have often cited this provision about whatever might be true as the extremes to justify the non-extremes. So this language is meant to deal with the extraordinary or the atypical, and the courts below have used it to say, how about the typical? How about if it doesn't mean any weapon in any context, how about every weapon in every context? Which is decidedly not the same thing, right? There is no evidence the Supreme Court intends this language to be a license to avoid common sense holdings in average context. Right. Much like the First Amendment. Right. Whatever might be true on some peripheries, even though there's some ideas that there's limitations to the First Amendment or limitations to freedom of speech or limitations to religion, just because there's limitations somewhere doesn't mean there's limitations everywhere. Unfortunately, Heller's acknowledging of exceptions has swallowed the rule because the courts of appeal in their infinite wisdom have looked at this language and said, if there's exceptions, then all the things are exceptions because I don't want to think about it. This case is not about extraordinary weapons lying at the outer limits of Second Amendment protection. The banned assault weapons are not bazookas, howitzers, or machine guns. Those arms are dangerous and solely useful for military purposes. Whether or not that's true or not, we don't really need to care right now. So if you want to quibble with that, don't worry about it. It doesn't matter right now. Instead, the firearms deemed assault weapons are fairly ordinary, popular, modern rifles. This is an average case about average guns used in average ways for average purposes. This is just ordinary, normal, everyday firearm ownership. Nothing exceptional here. Nothing extraordinary here. One is to be forgiven if one is persuaded by the news media and others that this nation is awash with murderous AR-15 rifles. The facts, however, do not support this hyperbole, and facts matter. Facts matter? In my law, it's more likely than you think. The Federal Bureau of Investigation does not track assault rifles, but they do track rifles, and they do show that killing by knife attack is far more common than murder by any kind of rifle. Any kind. By some margin. In California, murder by knife occurs 7 times more often than murder by any kind of rifle. For example, according to the FBI in 2019, California saw 252 people murdered with a knife, while 34 people were killed with a rifle. Any kind of rifle, not necessarily the AR-15. A Californian is 3 times more likely to be murdered by attackers' bare hands, fists, or feet than rifle. Those numbers are roughly correct for federal level as well. Been a while since I read the federal numbers, but that sounds about right. In 2018, the statistics were even more lopsided as California saw only 24 murders by some type of rifle. The pattern can be observed across the nation in which he doesn't have a footnote. But yes, this is true. I can tell you the last time I looked at the numbers that the number of people killed by any kind of rifle was eclipsed by the number of people killed by knives, the number of people killed by bludgeoning, the number of people just beaten to death. Yes, hands and fists, in fact, nationwide, have killed more people than all rifles of all descriptions. True in California, true nationwide. Statistics are fun. Mandalorian Y says, you're going over the full judgment? That's the working plan. This will be worth staying up. Yep, that's what we're doing, man. We're going to read this whole thing because I can. I believe in freedom, and I believe in the right to read this entire damn document. So that's what I'm going to do. Pre-Heller origin of the Assault Weapons Control Act. It is clear today that in the year 2021, individuals have the right to keep and possess dangerous common arms. The word common there is somewhat important to distinguish from uncommon or unusual weapons. So common there is key. California Assault Weapon Control Act was enacted in the year 1989, before Heller was a dream. Well, not literally, but close. In 1989, the California legislature was concerned that an assault weapon has such a high rate of fire and capacity for higher power that its function as a legitimate sport or recreational firearm is substantially outweighed by the danger it can be used to kill and injure human beings. The assault ban therefore banned assault weapons by specific make and model. The ban was a policy choice unencumbered by constitutional considerations. We hadn't discovered the Second Amendment yet, which is okay because we hadn't discovered the First Amendment until around 1939. So some of the amendments it took the Supreme Court longer to find than others. The California legislature weighed only until the firearms value of sports and recreation against the relative dangerousness of weapons and dangers of it being misused by criminals. It was a different time in legal history. It sure was. It sure was. In 1989, most judicial thinking about the Second Amendment was incorrect, and we can state that as a legal fact now because of Heller. That's just the legal fact. It was incorrect. We know that now. We probably knew that then, to be quite honest, but we definitely know it now. Prior to 2008, lower court opinions did not acknowledge the Second Amendment conferred an individual right or the right applied to the states. Yep. When the features-based definition was added in the year 2000, a citizen challenging the assault weapon ban in the Ninth Circuit was still incorrectly regarded as lacking basic Article 3 standing. Given the law at the time, yeah, because there's no standing, because the Second Amendment doesn't apply to you, because it's not an individual right. In 2000, judicial recognition of the individual right to keep and bear arms to be respected by states will come later. But it came eventually, so yay. In the year 1989, the California legislature was not concerned with maintaining room for a constitutional right to have a common firearm of one's choosing. Probably true because they didn't acknowledge that such a concept exists. In making its choice, the California legislature neither mentioned modern rifles as a means of self-defense nor the core Second Amendment right to appear to be any part of this consideration. Why would it be, though, right? The formal legislative findings say nothing about self-defense. The balance was simply about criminal use versus sporting or recreation. In this pre-Heller land, this policy choice made sense. Sure did, because that's the thing legislatures get to do with their time. We only need a rational basis because we don't have any of that pesky constitutional stuff, so rational basis will be fine. So yeah, sure, in 1989, no problem. On January the 1st of 2000, Senate Bill 23 went into effect, to adding to the ban features-based definitions of assault weapons. Previously, apparently, had been model-specific. And now they're going to go based on features instead of based on models. As this juncture is not clear why this was enacted, as there's no legislative history, the federal assault weapon ban was already in place. Maybe because they recognized it was 10 years, the federal law was going to expire 10 years. It was built into the law. And it did expire in 10 years. And besides, California is always free to create its own belt and suspenders approach, so why not? It may have been the fact that manufacturers began producing new firearms with similarities to listed firearms to circumvent the ban. Important for today's discussion is the fact that, once again, the legislature did not consider a right to keep weapons for home defense because, yeah, as Heller said, the very enumeration of a constitutional right takes out of the hand the power to decide on case-to-case basis whether the right is really worth insisting upon. Sure does. Whatever the Second Amendment might mean, whatever it might mean, it does definitionally, much like the First Amendment, take certain choices out of the legislature's hand. That isn't to say all choices out of the legislature's hand, which is where I, as a gun rights guy, get a little bit irritated at some of my friends on the Second Amendment side, because they say, well, that it's impossible there to be any regulations on the Second Amendment. I'm like, no, that doesn't make any sense any more than it does in the First Amendment, right? We have to have a slightly more nuanced picture of this. The California legislature was just as wrong as some of my brethren on the Second Amendment when they said the Second Amendment doesn't apply at all And my brethren on the Second Amendment says it applies always in every possible context. You guys are kind of equally wrong on that one. Much like the First Amendment and pretty much everything else, it requires a slightly more complex standing. That's informed by common law and history and the text and how the words were understood at the time. So, can there be regulations? Sure. Does that mean there can be all the regulations? No. And trying to figure out where that limit is where real law gets done. But of course, California wasn't thinking that far ahead, because why did they have to? Concerning the assault weapon ban, Prohibited Features Amendment, which sounds very similar to the federal one, which is also similar in this domain, the Attorney General has not identified any history or findings about dangers of pistol grips, flash hiders, scopes, flare launchers, or shrouds. Not that they really need to, because, yeah. The Legislative Information website lists several committee reports leading up to the signing, but there are no studies of criminal gun usage. There are no assault weapon experiences of other states. There are no public hearings. There's one indication that was said to be similar to a previous bill, which passed the previous year but vetoed by the then governor. The then governor issued a statement with his veto criticizing the approach and offering this analogy. If this bill's focus were high-speed sports cars, it would first declare them chariots of death, and then criminalize possession of ramblers equipped with racing stripes and wire wheels. Kind of, sort of, because the features ban was mostly cosmetic. So, yeah, this would be the rough equivalent of banning cars with racing stripes, which may be legal. Maybe. We could get into a First Amendment analysis on that one, but I don't know. But let's just say it would be. But yeah, that would be the rough equivalent. After this was amended, times changed. The federal ban expended 10 years after it was created, because that's what the law said. Heller was decided in 2008. McDonald was decided in 2010. Nevertheless, California continues to restrict assault weapons under the relevant law. The relevant law provides feature-based definitions of assault weapons, which today the plaintiffs challenge is unconstitutional. Great. So we have a statute. It says we're going to ban rifles that have these qualities on them. And they say, hey, you can't do that because the Second Amendment prohibits it. Because Heller talked about ordinary firearms kept for normal, ordinary, lawful purposes, as opposed to dangerous and unusual ones, right? And so, yeah, let's actually, think about it. Great. Well, before we can do that, we actually have to have a definition of an assault weapon, right? If we're going to ban assault weapons or really anything else, it would be helpful to know what that definition is. I make this point somewhat explicitly in light of the recent testimony of our would-be new ATF director, who, at Congress, said that he wanted to have an assault weapons ban, and then was unable to define what an assault weapon was. Now, I don't think it's particularly great that we should have an ATF director that wants to ban assault weapons, but I think if we're going to have one that wants to ban assault weapons, it will be helpful if they have some definition of what it is that they're banning. Just some idea, and he was unable to do it. Well, California has thought about this a little bit harder than our would-be ATF director, so they have some thoughts they'd like to share. So what's an assault weapon as far as California is concerned? Well, it is an assault weapon if it's a rifle, if it has one of three qualities. The first type is a semi-automatic centerfire rifle that does not have a fixed magazine. So that would be a detachable magazine. So it has to be a centerfire rifle as opposed to rimfire, which is, it doesn't have a fixed magazine, so therefore it has a detachable magazine. And it has one of the following additional features: a pistol grip that protrudes conspicuously beneath the action of the rifle, a thumbhole stock, a folding or telescoping stock, a grenade or flare launcher, a flash suppressor, or a forward pistol grip. Please take note that exactly 0 of these features in any way will change the nature of how the bullet comes out of the business end of the gun. Yeah. The second type is a semi-automatic centerfire rifle that has a fixed magazine able to hold more than 10 rounds. So they got you covered for those guys with a fixed magazine. The third type is a semi-automatic center-fire rifle that has an overall length of less than 30 inches. So for our purposes, really, the first one is going to be the dominant one. Center-fire rifle with a detachable magazine that has one of these additional features which somehow makes it more deadly. As an aside, the assault weapon epithet, and I like he describes it as an epithet. He doesn't describe it as a term. He doesn't describe it as a definition. He describes it as a swear word. Excellent. The assault weapon swear word, I love this guy, is a bit of a misnomer. The prohibited guns, like all guns, are dangerous weapons. However, these guns, like all guns, can be used for ill or for good. They could just as well be called home defense rifles or anti-crime guns. This is slightly off point because the California legislature, like every legislature, can define terms. So if they want to have something called an assault weapon, they could arose by any other name. You know what I mean? And then they can just define it. At least they tried, unlike the ATF director. So hey, one bonus point. One bonus point for California over the ATF director. They are at least trying. The mechanical design features that identify a rifle as an assault weapon, it is argued, tend to help a person shoot a rifle more accurately under pressure. The plaintiffs make the point that this is a better condition for all lawful uses, which is a more accurate gun is better for everybody. So yes, it might make the gun more accurate, but for good or for ill. After all, responsible gun owners worry about the ending point of every round fired. If shooting in self-defense, a home defender wants every round to hit only the attackers. So yes, you're forcing us to own weapons that by your own reasoning are less accurate. So, yeah. In contrast, the Attorney General over here argues that better accuracy makes a more dangerous weapon. According to the Attorney General, assault weapons enable a shooter to fire more rounds rapidly in a greater period with greater accuracy, increasing the likelihood that more individuals will be shot and suffer more numerous injuries. The implied context is a mass shooting. In the terrible mass shooting context, which fortunately is a rare event, go you, Benitez, by not buying into that bullshit of like it happens every day. When we're really talking about what we're really talking about, mass shootings, it's rare. Thank you. Reducing the number of innocent victims is the state's goal, although it's not at all clear that a less accurate rifle would reduce the number of victims. A less accurate rifle in the hands of a mass shooter may very well result in different victims, but not necessarily less. Should we chide him because better is fewer rather than less? We'll give him a pass. On the other hand, in the self-defense context, which seems to be more common, taking accurate shots at attackers is vitally important for an innocent victim. While a state ought to protect its residents against victimization by a mass shooter, it ought to protect its residents against victimization by home-invading criminals. But little is found in the Attorney General's court filings reflecting a goal of preventing violence perpetrated against law-abiding citizens in their homes. Instead, the state's litigation stance is more like the view recently expressed by police chief in Oakland, California. We do not want victims to arm themselves. We want them to be good witnesses. Of course, a dead victim is a lousy witness. Wow. Wow. That's a lot of burn, man. That's a lot of burn. State of California says we don't want victims to arm themselves. We want them to be good witnesses. And Judge Benitez over here, just breaking out the judicial's backhand, says a dead victim is a lousy witness. Wow. We know. I think Judge Benitez might actually be wrong, because I think Judge Benitez is proving quite well you don't need an AR-15 to be deadly. Wow. Criminal penalties. The state prefers a policy of residents not arming themselves with assault weapons, and for when they do, arresting said residents. The relevant law imposes a federal criminal penalty for anyone who manufactures, distributes, imports, keeps for sales, offers for sale, or lends to another an assault weapon. The prescribed prison sentence for these malum prohibitum crimes, which means they're bad because we say they're bad as opposed to inherently bad, in case anyone wants to know. The alternative to that, by the way, is malum in se. So crimes come in two versions, malum in se and malum prohibitum. Malum in se is it's bad because it's inherently bad. Malum prohibitum is it's bad only because we said it was bad. So the sentences for these violations are 4, 6, or 8 years. One who merely possesses a weapon is guilty of a misdemeanor or a felony. In other words, the criminal sanction for possession of a gun deemed an assault weapon is a wobbler. Ooh, is a wobbler. And can be sentenced as either a felony or a misdemeanor. If one possesses only one or two properly registered pre-ban assault weapons, the crime is a misdemeanor for a first offense. Beginning January 1st of 2020, a prosecutor may, in lieu of criminal possession for mere possession, institute civil action. As one commentator has described it, mere possession of an object that's commonplace and perfectly legal under federal law, and in 44 states will land you in prison, will result in your loss of rights, including your right to vote, and probably will cause irreparable harm, as well as to your liberty, all in despite of absence of even a single victim. Ouch. Ouch. Modern rifles. The Second Amendment protects modern weapons. Yes, in much the same way as the First Amendment protects modern versions of speech. And the Fourth Amendment, for that matter, protects modern versions of homes. The Constitution is meant to be enduring. And so all the people out there who are like, well, the Second Amendment was written at a time when only there were muskets, which, I will contest that factually, but whatever, presuming it to be valid, then the First Amendment only protects pamphlets and standing on the corner with your soapbox and books and newspapers. First Amendment apparently has nothing to say about radio, television, the internet, social media. First Amendment's completely irrelevant to all that by that logic, right? Right? The firearms banned by this relevant law are modern weapons. They are principally AR-15 type rifles, pistols, and shotguns. Plaintiffs and others refer to them as modern sporting rifles, although they're clearly useful for more than just sport. They are modern rifles that do not look like iconic rifles from years gone by. Depends on your point of view. They're fabricated with synthetic polymers and anodized aluminum in Creoc colors of black and brown and green. Parts once made of solid wood on guns of the past are gone, or relatively rare, that's true. These modern rifles are constructed of lightweight alloys and titanium nitrate barrels in angular skeletonized shapes. To those of us who grew up watching westerns with John Wayne or Chuck Connors on television, modern rifles just do not look like rifles. The AR-15 platform in particular is open source design and includes firearms made by numerous manufacturers under different product names with countless variations and adaptations. In fact, the platform's ability to accept modifications with ready-made retail parts without the need for specialized tools is part of what makes these rifles popular. Sometimes, sometimes jokingly, sometimes degradingly, it's called Barbie for boys for this reason. So many accessories to collect. What advances in firearm design in the future holds for these arms are yet to be imagined. When the term modern rifle is used in this opinion, principally refers to a rifle built on this AR-15. So when we're going to talk about modern rifles, we're just going to talk about the AR-15 because that's the one that you guys are all super fascinated about for some reason. So we'll just talk about that one because why not? Let's start with the law. That's always a good place to start. What is the law? The Second Amendment provides, and I can quote this from memory verbatim, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Supreme Court recognizes that framers and founders of the 14th Amendment counted on the right to keep and bear arms as fundamental rights necessary to our system of ordered liberty. The right is incorporated against the states. Although the Attorney General sees it differently, the Supreme Court also recognizes the Second Amendment guarantees includes a right to keep and bear firearms that have some reasonable relationship to preservation of a well-regulated militia. Citing Miller. All right, so we're going to go and try to extract some value from Miller. I don't mind you doing this, but I'm just going to take note that for me, I think Miller is best probably ignored. The reason I say that is because Miller is a bit of a garbage opinion. It's a U.S. Supreme Court opinion to be sure, but it is poorly written. It's hard to understand exactly what they're talking about. Only the U.S. government argued the case. Miller was dead. His attorney refused to show up because he wasn't getting paid. So only the U.S. government argued the case, and the opinion itself is just badly written. It's a little Rorschach-y. It kind of means what you want it to mean. But sure, let's go back to Miller and try to extract some value out of this case. All right. Miller implies a weapon is commonly owned and used for common defense for a militia is also protected by the Second Amendment. Heller and Miller are consistent. Well, that much is true because, again, as I just said, Miller is probably, a bit Rorschach-y. Heller also took an expansive zone of protection for weapons that could be used by the militia and focused on the core use of firearms for self-defense. The Heller court determined that the right to keep and bear arms is an individual right held by the people and not limited by its prefatory clause, or otherwise known as its preamble. A well-regulated militia not only the right to carry and possess firearms in connection with militia service. As McDonald itself puts it, in Heller, we've recognized the codification of this right was prompted by fear the federal government would disarm and thus disable militias. But we've rejected the suggestion the right was valued only as a means of preserving the militia. On the contrary, we stress the right was also valued because the possession of firearms was thought to be essential for self-defense. As we put, self-defense was a central component. So, much like the preamble of the Constitution itself, or much like the preamble in Article 1, Section 8, Clause 8, which deals with intellectual property, the preamble here speaks to the reason, perhaps, it was created, but it does not limit it. The preamble does not limit the Constitution. It speaks to why it's good, but it's not operative. It's philosophical. Much like the preamble's treated in Article 1, Section 8, much like the preamble's treated here. It's prefatory. It does not influence the operative text. In Castino, the court has underscored these 2 points. One, the Second Amendment extends the very least to modern arms useful for self-defense in the home. The Second Amendment protection includes common arms and weapons that may also be useful in welfare. They may have both possible uses. Sure. With these principles in mind, it's time to put the constitutionality of the assault weapons ban to the test. I don't know. I really like this guy's writing style. It just flows very easily. It's very easy to read. It's very easy to understand. It just flows like one continuous story. I like this guy's wording choices. I like this guy's writing. He's pretty good. It's very, very pleasant to read. Which can definitely not be said for all judicial opinions, let me assure you. And I'm sure you guys know that because you've been here long enough and have me read enough opinions. 2 tests will be used. The Heller test and the Ninth Circuit 2 levels of scrutiny test. The Heller test is a test that any citizen can understand. Yeah. Heller asks whether a law ban of firearms that's commonly owned to law-abiding citizens for lawful purpose. It's a hardware test. Heller draws a distinction between firearms commonly owned for lawful purposes and unusual arms adapted for unlawful uses, as well as arms solely useful for military purposes. Sure. As applied to the assault weapons ban, the Heller test asks, is a modern rifle commonly owned by law-abiding citizens for lawful purposes? For the AR-15 type rifle, the answer would be yes. The overwhelming majority of citizens who own and keep the popular rifle and its many variants do so for lawful purposes, including self-defense. Under Heller, that's all that's needed. Using this easy-to-understand test, it's obvious that the ban is unconstitutional. Under the Heller test, judicial review can end right here. Well, that's fun. That's fun. I have stated the issue, done the analysis, and reached the conclusion all within one paragraph. That's good stuff, man. I have stated the issue, done the analysis, and reached the conclusion inside a Twitter tweet, basically. Yeah. Popularity in California. Modern rifles have been immensely popular in the United States, even in California, despite being banned. According to the state's own evidence, there are 185,569 assault weapons under California's definition currently registered with California. Another 52,000 weapons were backlogged and left unregistered when the registration period closed. That's hilarious. There are likely many more in California, according to the state's evidence. 4.2 million adult Californians personally own a firearm, and Californians own an estimated 20 million firearms. According to the survey, of the 20 million firearms, assault weapons make up approximately 5%, or approximately 1 million. Yeah, maybe. Especially the way California defines them. Californians buy a lot of firearms. In the year 2020 alone, residents bought 1,165,309 firearms. From January 1st of 2021 to March 12th of 2021, they bought 180,058 more guns. Of the total of 1,345,367 new guns purchased since January 1st of 2020, rifles make up 368,337, which is basically 1 million other. So it's basically 1 million other stuff, 3.6 or 0.36 million rifles. If 48% of rifles sold nationwide are modern assault rifles, it can be inferred that Californians would have purchased modern rifles at the same rate. So now we're going past the issue of the ban, because it's a little bit, if you say what's normally owned, you can't say, well, because we banned it, it's not normally owned. So if not for California, what would our citizens have done, right? And hey, why not? They're just basically the same as everyone else in the absence of anything else. Sure. So of these 368,000 rifles, it is reasonable to infer that 176,801 additional modern rifles would have been added to the stock if not for the ban. Some fraction of this 368,337 rifles actually brought to California may well be stripped-down, featureless versions. Among people in California purchasing all guns, there are approximately 412,059 first-time buyers, which is roughly 1/40th of the entire state. That's a lot, man. That's a lot. 1/40th of the entire state is a first-time buyer since 2020. The Dentalist says, one paragraph to do business, 90 pages of just showing you why the law is stupid. Yeah. Maybe. Thank you for the super chat. Nationally, modern rifles are ubiquitous. In 2018, the most recent year with data, 1,954,000 modern rifles were manufactured or imported to the United States. Over the last 3 decades, 19,797,000 modern rifles have been manufactured or imported, and the numbers are increasing. Almost half of these rifles are modern rifles. That's 664,360 rifles. The same year, that's 2018, the same year, 34% of buyers purchased a modern rifle for personal protection, while 36% purchased it for target practice or informal shooting, and 29% for hunting. In contrast, only 5% of traditional rifles were bought for personal protection. For female gun buyers in 2018, after a handgun, a modern rifle is the next most popular choice. The same is true of all first-time gun buyers in 2018. During 2018, approximately 18,327,314 people participated nationally in target and sports shooting, specifically with a modern rifle. Maybe it's common. Maybe it's ordinary. Maybe this is not whatever the language in Heller talking about the exceptional case was trying to convey. Nationally, 3-gun shooting is the activity with highest mean days of participation, 23.8 days. That's a lot, man. That's a month. But the next highest activity is target shooting with a modern rifle, 15.3 days. In the West recent, target shooting with a modern rifle is a top activity. It's more popular than the Ford F-150 pickup truck. You know, I love this guy so much. I love this guy so much. It's more popular than the F-150 pickup truck, which is particularly rich for a couple reasons. The F-150, to the best of my knowledge, and someone will correct me if I'm wrong, but I'm reasonably sure, is only sold in Canada and the United States. That being the case, however, for the last 38 years straight, it has been the most popular car sold in the United States. Not the most popular truck, the most popular car. Even though it's only sold in the United States. The F-150, for 38 years, has been the most popular car sold in the United States. One might conclude the F-150 is in ordinary and common use in the United States. But the assault weapon, well, the F-150 ain't got nothing on that, man. Ford's in the wrong line of business. Modern rifles are popular. Modern rifles are legal to buy, build, and own. There are probably more modern rifles in circulation than there are Ford F-150 pickup trucks. In 2018, 909,330 F-150s were sold. A million were sold in the U.S. But twice as many modern rifles were sold. Imagine, every time one person passes a new Ford pickup truck is a reminder that 2 new modern rifles have been purchased. Wow. That's a lot of modern rifles owned by Americans. Other courts agree, even accepting the most conservative estimates. The assault weapons are in common use. We think it's clear enough that these are indeed in common use. Wow. The Supreme Court has implied that as few as 200,000 stun guns owned nationwide by law-abiding citizens is sufficient to show common ownership and receive constitutional protection. Yeah, there was a somewhat very low publicized Supreme Court opinion that said stun guns receive Second Amendment opinion. It wasn't very long either. It was also kind of thrown away in an orders list. But yeah. Based on evidence presented, it can be confidently said that between 200,000 and perhaps 1 million modern rifles are owned in California alone. Based on lack of evidence at trial, these 200,000 to 1 million guns are often used in crime. It's reasonable to infer that most are owned by law-abiding citizens who only use them for law-abiding purposes. Yeah, not a lot of evidence here that these 200,000 to 1 million guns are used often in crime. Seems like, for the most part, they're not used in crime at all. After handguns, modern rifles are probably the most popular firearms in America. They're quietly owned by millions of law-abiding citizens for lawful purposes, ranging from home defense to sporting. Yet California has banned and continues to ban these popular rifles. Perhaps the state has a long-range plan of taking incremental steps towards more and more gun control. No, that's just, we can't have that. We can't have this rampant undue speculation. We can't have this rampant undue speculation that maybe this is just part of a long-range plan of gun control. Where are you coming up with that strange idea? It should be obvious that banning total extinction of the Second Amendment, no amount of common sense gun control laws will prevent criminals from misusing guns. Whatever the reason, these laws are still in the books, like Victor Hugo's Inspector Javert, relentless searching for Jean Valjean. California continues to amend its statutes to prohibit more and more firearms. At the core, this is simple. He is so much talking down to everybody, and I love it. He's like, this is simple, you idiots. This is simple. He's just slapping everyone around. He's not only slapping the Attorney General around, he's slapping other courts of appeal around, other districts. He's slapping everyone around. He's slapping around the federal judiciary at this point. Someone ate their Wheaties that morning. At the core, this is simple. Like cases of Heller and McDonald, the government bans an entire class of very popular hardware, firearms that are lawful under federal law, and most laws that are commonly held for law-abiding Americans. Under no level of heightened scrutiny can the law survive. Ooh, burn. Oh, burn. Oh my God. Wow. That's like some gangsta shit there. So most of the time in these opinions, we'd get some very long discussions of strict scrutiny or intermediate scrutiny, which, I'm not necessarily opposed to. That's perfectly fine. But Judge Benitez over here basically dismisses all of strict scrutiny analysis and all of intermediate scrutiny analysis, stuff over which pages and pages and pages of ink have been spilled in other decisions. And he dismisses it all in one sentence. Wow. It's like, without even really mentioning it, he just dismisses all of it. Wow. The Ninth Circuit has yet to adopt this easy to grasp test. Instead, the Ninth Circuit uses what it calls a two-step framework. In practice, the two-step framework is not particularly simple. We've understood Heller to require one of three levels of scrutiny. Well, Judge Benitez kind of disagrees with you here. He's not about that levels of scrutiny stuff. If a regulation amounts to destruction of the Second Amendment, it's unconstitutional under any level of scrutiny. A law that incorporates the core of a Second Amendment and severely burns it receives strict scrutiny. In other cases, intermediate scrutiny. Most courts select intermediate scrutiny in the end. Truer words, man. Intermediate scrutiny turns for a reasonable fit. Modern rifle ban is suspect even under the most lenient form of scrutiny because assault weapon law are not reasonably fit. But first, Ninth Circuit's two-step framework requires a pre-check for Second Amendment coverage. Okay, so he's about to slap everyone down. So first of all, he dismisses the intermediate scrutiny analysis completely. And now he's like, I'm about to school you all that you guys are idiots even when you've been applying it. But I'm not going to do that right away. I'm going to make you suffer a little bit more first. Before I point out how you're horribly, horribly wrong, let's pre-check it against the Second Amendment first. The first step asks whether the regulation is one of the presumptively lawful regulatory measures identified in Heller, or whether the record includes pervasive evidence establishing the regulation at issue imposes prohibitions that fall outside the scope. In other words, if a regulation is presumptively lawful, the inquiry ends. The California modern rifle ban is not excused from judicial scrutiny on either ground. First, a complete ban on modern rifle is not one of the presumptively lawful measures identified in Heller. Second, a ban on modern rifles has no historical pedigree. Prior to 1990, there was no national history of banning weapons because they were equipped with features like pistol grips, collapsible stocks, flash hiders, flare launchers, or barrel shrouds. In fact, prior to the 1989 ban, so-called assault weapon bans were lawfully manufactured, acquired, and possessed throughout the United States. The Attorney General disagrees and claims that our assault weapon ban is analogous to a handful of state firing capability regulations in the 20s and 30s, and one from District of Columbia from 1932. These laws were repealed long ago. The only law that's remained in effect the Attorney General describes as the District of Columbia law is a 12-shot restriction on semi-automatic weapons. The District of Columbia regulation seems to mix terms. Ooh. Section 14 prohibits possession of any machine or sawed-off shotgun. Section 1 defines a machine gun as a firearm that shoots automatically or semi-automatically more than 12 shots without reloading. So in DC, a machine gun is a semi-automatic rifle. Please take note. It is true that during its existence, the District of Columbia regulation has applied to a semi-automatic pistol. However, in the 76-year existence of the District of Columbia regulation, did not stand in the way of the Supreme Court when it dismantled that regulation. Long-standing can go straight to hell. The District of Columbia regulation that the California General relies on was not regarded as long-standing or presumptively lawful. It was not even mentioned. In fact, the Heller opinion broadly cautions courts deciding whether analogous regulations are long-standing, saying, "We would not stake our interpretation of the Second Amendment on a single law in effect in a single city that contradicts the overwhelming weight of evidence regarding the right to keep and bear." But that's exactly what you just did. A single regulation in a single city, which the Supreme Court explicitly told you. You know? Yeah. The assault weapon ban of California has no historical pedigree. With this pre-check completed, the hard work begins. Step 2. Since the assault weapons ban is not presumptively lawful or historically permitted, the Second Amendment applies. At Step 2, a court selects one of 3 levels of scrutiny. Here, a bullseye test is used. A target is set up. At the center of the target is the core of the Second Amendment right. The first measures how core the statute hits to the bullseye. The second step measures how severely the statute burns the right. Because Heller did not specify a particular level of scrutiny, the courts have determined the appropriate level by determining how close it comes to the core and the severity of the law burden. The modern rifle ban strikes at the acknowledged core of the Second Amendment, which is the right of self-defense in the home. Heller has held that the core Second Amendment right is the home because, as always, the home is special. Going straight to the core, the California law criminalizes modern rifles kept or possessed everywhere, including in the home. There are no current exceptions for ordinary citizens. A Californian who picks up an unregistered AR-15 style rifle solely to defend his family has committed a crime. It does not matter if the home was burglarized last night or likely to be invaded this night. When it comes to self-defense, the assault weapon ban hits the bullseye, a direct burden on this core right. Preach it, brother. Preach it. Preach it. Goes directly to the ability of the core of the Second Amendment. The California statutes not only directly burn this core, but impose the severest burden, a complete ban. When a severe regulation on a core right amounts to destruction, it's unconstitutional under any level of scrutiny. Burn, everybody, burn. He is burning so many courts of appeal right now. I can feel the Fourth Circuit's Court of Appeal burning from over here, man. A law that imposes such a severe restriction on the fundamental right of self-defense that amounts to destruction is unconstitutional. Judicial review could end right here. But wait, there's more. I could stop. Stop, it's already dead. I could stop, but you don't want to roll with me. I'm a mother effing PAMP. Assuming the assault weapon ban requires some form of lower scrutiny, which prudence dictates a lower level must be selected under the Ninth Circuit framework. A law that implicates the Second Amendment right and severely burns it are affected in some lesser way, we apply intermediate scrutiny. Well, all right, let's give that a shot. The Attorney General argues that this lower form, intermediate scrutiny, should apply. Most courts have applied intermediate scrutiny. They sure have. They sure have. Would you like to beat them to death with it? Assault weapon ban would fail strict scrutiny, but even under intermediate scrutiny, it fails to have a fit. When intermediate scrutiny is selected, another two-part test is required. The government's interest must be important, and the fit of the objective must be reasonable. As always, the state's objective with these laws pass the first prong of the test. Reducing crime is an important objective. Part 1 is a given. Part 2 is where the rubber meets the road, right? So if you're looking for a reason to regulate firearms, you can come up with a reason. You can even come up with a reason that's going to pass strict scrutiny. But of course, then the other half of the equation is where things matter. How narrowly tailored is it? Or how is it the least restrictive means or whatever, right? So you have reasons, you have motive, but you need to have more. Part 2 requires a reasonable fit, but does not demand the least restrictive means of furthering the objective. Least restrictive would be a test for strict scrutiny. Instead, the Ninth Circuit has said, a state statute simply needs to promote a substantial government interest that would be achieved less efficiently absent the regulation. This watered-down test has been criticized. That's not the right test for intermediate scrutiny. You're right. Even in its diluted form, though, the assault weapon ban fails the test. So the judge is just smacking everyone around. He says, hey, Ninth Circuit, this is not the test for intermediate scrutiny. It's not. It's not. You got it wrong. They did. But it doesn't matter because even in your weakened form, it still fails. It still fails. Even in your weakened substitute straw man, you can't make it work. Under the relaxed test, a state could enter a person's home without warrant and seize the guns in violation of the Fourth Amendment. What other government mischief might be tolerated under such a deferential standard? Ooh, burn. Burn. Yeah, if we applied this in the Fourth Amendment context, we could just have searches and seizures without that pesky warrant. What else might fall? As an aside, this court notes that such a deferential treatment of the government restriction of the Second Amendment is not to be found anywhere in the Constitution, the Bill of Rights, or the Second Amendment, which you can make a colorable case for under the Fourth given its language, but not so much for the Second. There's hardly any governmental institution that cannot be rationalized as important. For example, California's Japanese internment camps. Oh my God, no. Oh my God. Ooh. As an aside, this court notes that such deferential treatment of government restrictions of Second Amendment rights is not to be found anywhere in the Constitution, the Bill of Rights, or in the text of the Second Amendment. And there's hardly any governmental intrusion that cannot be rationalized as important. For example, a California Japanese internment camp. Like curfew, exclusion of those of Japanese origin was deemed necessary because the presence of unascertained number of disloyal members of a group, most of whom we have no doubt were loyal. It was because we could not reject the finding of military authorities it was impossible to bring about an immediate segregation of disloyal from the loyal that we sustained the validity of a curfew applying to the whole group. That hurts. That hurts. We're on page 24 of 94. We're nowhere close to done. We're on page 24 of 94. We are nowhere close to done. And it is just brutal, brutal, brutal. While the Second Amendment intermediate scrutiny test is overly relaxed standard, it is not a free pass. When subjected to intermediate scrutiny, the state is not by insulated from a meaningful review. Even under intermediate scrutiny, a court must determine whether the legislature has based its conclusion upon substantial evidence. The government must do more than simply posit the existence of diseases sought to be cured, and demonstrate the recited harms are real, not merely conjecture, and the regulation will in fact alleviate these harms. What our decisions require is a fit between legislative ends and means chosen to accomplish those ends. A fit that's not necessarily perfect, but reasonable, represents not only necessity, but single best disposition of one scope is in proportion to the interest served. That employs not necessarily the least restrictive means, but a narrowly tailored one to achieve that objective. That would be the right language, by the way. In Turner 2, an expanded record permitted the court to consider whether Congresses must carry provisions were designed to address a real harm and whether those provisions will alleviate it. Moving through the record here, it becomes clear that California's assault weapon ban by prohibited feature was not designed to address a real harm, and even if it did, does not alleviate that harm in some material way. Guiding intermediate path are some checkpoints. Plaintiffs do not have to shoulder the burden of proving they are entitled to enjoin the Second Amendment. The command of the Second Amendment is the right to keep and bear arms shall not be infringed. It follows that when a citizen complains in a facial challenge, the government is infringing. The government must carry the burden of justifying the restriction. Since the state bears the burden of justifying the restriction, it must affirmatively establish the fit that we require. If the burden of proof is shouldered, the government regulation survives. If it does not bear it, its citizen prevails. The Attorney General takes a different view. He says the plaintiff bears the burden at step 1, citing some case from the Third Circuit. But that decision from the Third Circuit placed the first step of the burden on the plaintiff for an as-applied challenge, which makes sense because in that case, the plaintiff claims to be the exception to a rule, right? That would be the difference between an as-applied challenge and a facial challenge, right? In a facial challenge, you're saying the rule sucks. In an as-applied challenge, you're saying the rule may not suck, but it sucks as applied to me. So that's a different burn, right? Plaintiff in this case brings both facial and as applied. The Attorney General also objects the state should not have the initial burden of proving a prohibited arm is not commonly possessed. But this is exactly wrong. The constitutional imperative is on the government not to infringe. The correct stating orientation is that no arm may be prohibited. That would be the baseline. But kind of like the First Amendment for that matter. No speech may be prohibited. That would be starting point, right? If, not necessarily the ending point, but the starting point. If a plaintiff challenges the prohibitions on the government first to prove that the banned arm is dangerous or unusual, and if not, that it's not commonly possessed, or commonly possessed by law-abiding citizens, or for lawful purposes or malicious readiness. If the state cannot prove it, the regulation must be struck down. This is your burden of proof. Suck it. The presumption in favor of a right of a possessing citizen arm was made in adoption of the Second Amendment. The government may carry its burden in a myriad of yet undefined ways, but it is the government's burden. In this case, there's sufficient evidence to prove AR-15 rifles are commonly owned by law-abiding for lawful purposes like self-hunt, defense, and hunting. At the same time, there's very little evidence regarding the commonality of AK-47 type rifles or semi-automatic pistols or whatever they are, because that wasn't at issue in this case. So, and then there's a little footnote here discussing that. So there's not much evidence regarding commonality of AK-47 rifles or semi-automatic shotguns or assault pistols, whatever they are. Yeah, we're not sure what an assault pistol is either. Likewise, there is little evidence that semi-automatic AK-47 rifles or semi-automatic shotguns or assault pistols have been used unlawfully in California. Because the government bears the burden and has not proven they're uncommon and dangerous, these arms are presumptively lawful. The government must now demonstrate an outright prohibition on acquisition survives scrutiny. The state's evidence is wide but shallow. It's not enough to carry the burden. Oh, I feel it over here. I feel it just collapsing. Oh, it's so bad. It's so bad. Oh, wow. If you're enjoying this content, may I please ask that you subscribe if you've not subscribed already? Could you please hit the like button if you've not hit the like button? And if you're not a member, please hit the join button or follow the link provided by Streamlabs to help support the channel financially. I'd really appreciate it. This is good shit. Wow. Checkpoint number 2, alternative guns. Rephrasing the Attorney General's argument, California's modern rifle ban does not destroy a fundamental right because some guns remain lawful, which I take an immediate umbrage at because it's a little bit like saying banning books is okay because they're still newspapers. Running through the arguments is the rationale that no harm is done because a citizen may buy and keep traditional rifles and featureless rifles, traditional shotguns and handguns from a state-approved roster. What is not mentioned is that the handgun roster is also shrinking. Therefore, according to the Attorney General, the constitutional right is only mildly or moderately burdened by this ban because alternatives remain. The state's position is that configuration that is prohibited under the Assault Weapon Act is not a configuration or a prohibition that severely burns the right because individuals can use a Ruger Mini 14. An individual can use an AR-15 as long as its rimfire takes 22. With all features, because then it wouldn't be centerfire. It'd be rimfire. So you can have all the features you want if it's a 22, sure. Or a centerfire automatic rifle with detachable magazine that has no pistol grip, telescoping Scott, forward pistol grip, or flash suppressor. The problem is the alternative remaining argument has no limiting principle and would justify incremental firearm bans until there's only one single shot Derringer remaining for lawful defense. So it has no limiting principle. So it would justify bans until all that's left is a single shot Derringer. Nice. The same argument that a handgun ban might be justified because alternatives are available was rejected in Heller. Is no answer to say permissible ban is okay so long as other things remain lawful. Checkpoint number 3, legislative history. As part of an intermediate scrutiny review, a court may consider legislative history of an enactment. While there are legislative findings for enactment of the assault weapons ban, there are none for the prohibited features amendments. The enactment's findings indicate no consideration by the legislature was given to the ban on home defense or militia use. That makes it challenging to determine the rationale for later amending. The municipality's evidence must fairly support the rationale. And while courts should not conflate legislative findings with evidence in a technical sense, neither should they credit facially implausible findings. The Ninth Circuit has said this as well, using their own language against them, ma'am. In assessing congressional judgment, we do not impose an unnecessarily rigid burden of proof. We allow the government to rely on a material reasonably believed to be relevant to substantiate its interests. That standard applies because we're weighted with a legislative judgment, not evidence at a criminal trial. Thus, we do not require scientific precision. We only ask where the evidence fairly supports a reasoned conclusion. When empirical evidence is incomplete, we must accord substantial deference to the predictive judgments. And then we go into Section 1A, a faulty prediction. Ooh. In 1989, California's legislature predicted an assault weapon ban would eliminate or reduce mass shootings. It has not turned out that way. As discussed later, even in the state's evidence demonstrating that mass shootings with assault weapons continue to occur at the same rate as before the ban. If Congress is correct, the national assault weapon ban also did not work. Congress passed the 1994 ban with a 10-year sunset provision and allowed it to lapse. Congress has not reenacted the ban. There's disagreement by academics over the effect of the ban on reduction in mass shootings, and even those who saw a good effect to see it slight and diluted by other aspects. State law assault weapon ban remaining effects have little to show. Nevertheless, California continues its experiment. No case is held. Intermediate scrutiny permits a state to impinge on a Second Amendment right by continuing to employ a known failed experiment. Wow. In addition to the assault weapon ban history, the Attorney General cites the legislative history of the 1994 federal ban. Specifically, he cites a House report. The Attorney General says Congress found assault weapons to be weapons of choice among drug dealers, criminal gangs, hate groups, mentally deranged. Actually, this part of the House report simply lays out evidence received during the 5 years of the hearings. It does not contain findings approved by Congress. Oh my God. Oh, Burn. Oh, wow. So not only are you going to legislative history from a different jurisdiction to support your ban, you're not reading it right. Congress didn't say we're finding these things. Congress simply said, here's some evidence that was supported, that was sent to us. These aren't findings. You can't even read the report right. Wow. Burn. Burn. The report describes testimony along these lines, but describes the views of several victims, of which the Attorney General does not cite. One victim testified that although they'd been shot with an assault weapon, they were angry that tragedy was being used to deny law-abiding citizens the right of firearms in their choosing. Enforcing laws against criminals already on the books. You cannot ban everything in the world that could be used as a weapon because you fear it, don't understand it, or don't agree with it. Another witness positively identified that he used a Colt AR-15 to capture a wanted criminal in the act of burglarizing his parents' home. At least Congress considered. Burn. At least Congress considered the self-defense rights before passing the ban. Oh my God, burn. 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 They at least thought about it before they passed their ban. Unlike you, California, who gave this no consideration. Also, they weren't findings, and you can't read. We're going to be here a while, kids. We're going to be here a while. You better strap in, because Uncle Blackleaf is here for it. Uncle Blackleaf is here for the rich Benitez tea, and we're spilling this tea all over the state of California. Forget the Boston Tea Party. This is a Sacramento Tea Party, baby, and it's brutal. Wow. The same cannot be said for California's ban. It's also worthy of note that gun control has been a hot political issue for 17 years, but it has not been renewed. Checkpoint number 4. News reports and police reports. News reports are normally considered inadmissible hearsay, but both sides offered into evidence news articles and magazines and expert testimony relying on newspaper articles about gun events. News reports to which the parties make no objection are admitted into evidence. But it begs the question, what are the actual police reports or criminal reports? So, yeah, you offer these news reports, but where's the underlying stuff? Why are the only collections of offensive or defensive use maintained by biased organizations? Ooh. How reliable can a news reporter be after the fact, identifying a firearm as an assault weapon, or determining the size of an ammunition magazine, or the count of rounds fired? Yeah, these news reports may not be accurate. Yeah, one would expect a police report to accurately record this, unlike, random news articles. While the plaintiffs may have difficulty attaching copies of actual police reports, surely the Attorney General could. But the Attorney General has not offered a single Californian police report. There were 161 mass shootings in the last 40 years, but there's no testimony from any of the witnesses. There were instances of defensive gun use, but no testimony from any defensive gun user. The Attorney General argues that a citizen defending himself really needs only on average 2.2 shots, but there's no testimony from any home defender. No victim was called to testify about how many shots they would have needed. Defense of the home is not a hypothetical event. While there are not hard numbers, surely it must happen a lot. Approximately 1 million burglaries of the home occur every year, according to the Department of Justice. The Attorney General does not take offense of the fragility of evidence. Instead, the Attorney General argues the law excuses it. So the Attorney General is not offended by the fact that there's no evidence. He says the law doesn't require him to need it. He reminds us under intermediate scrutiny, the government may rely on evidence reasonably believed to be relevant. He says the evidence need not be particularly robust or pervasive. On the contrary, he says evidence need only fairly support the government's conclusion. For Second Amendment scrutiny, many courts have applied a lower standard, but even lowest form of scrutiny does not require obseisance from the fact finder. Yeah. So you may not need much, but I don't need to be obedient to the fact that there's no evidence. The Attorney General's lack of direct evidence is noted. There's no direct testimony. Sociologist studies disagree and speak of further studies, as legislative history tells only of prosaic interests without regards to constitutional rights. The evidence. Approximately 14,000 pages of evidence and testimony have been submitted and reviewed by this court. Only the most salient is addressed. Different types of trial evidence were presented and evaluated in the manner required. Fact witnesses were judged on accuracy and credibility. Expert witnesses were judged and their opinions given the appropriate weight. Because firearm possession for defense of home, self, and family is at the core of the right, it's important to know if there's evidence of modern rifles being used for this purpose. Recall that the relevant law has no present exception allowing Californians to lawfully acquire a modern rifle for home defense. There are no exceptions for urban dwellers, and there are no exceptions for rural farmers. There is no exceptions for wealthy targets. There's no exceptions for the impoverished. Without question, there's clear evidence that AR-15 rifles are and have been used for self-defense. For example, in one case, an AR-15 was used in Florida by a pregnant wife and mother to defend her family from two armed, hooded, and masked home intruders. As soon as the home intruders entered the back door of her home, they pistol whipped her husband, fracturing his eye socket and sinus cavity. They then grabbed the 11-year-old daughter, but before they could do any harm, the pregnant wife retreated to the room and got the AR-15 and killed one of the attackers. Boom on you, pregnant woman. Boom on you. Boom on you, ma'am. These two attackers come inside the door. They pistol whip your husband, and you, pregnant woman, go to the bedroom, get the AR-15, and implement it. You are my hero. You are my hero. It does not require much imagination to guess what would have happened next if the wife and mother did not have a firearm, or if she emptied the magazine before the attackers had fled. The quiet click would be sickening, and probably with tragic results. The state contends that one does not need more than 10 rounds. That is easy to say. Perhaps one should imagine the terror that would have gripped this wife and mother from the sound of that click, out of ammunition, helplessly watching her husband be murdered, her daughter be raped and murdered, and the enraged men coming for her. Ooh. 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 I feel like we need to read that again. Wow. Wow. It does not require much imagination to guess what would have happened next if the wife and mother did not have the firearm, or if she emptied the AR-15's magazine before the attackers had fled. The quiet click would be sickening, and probably with tragic results. The state contends one does not need more than 10 rounds. That is easy to say. Perhaps one should imagine the terror that would have gripped this wife and mother from the sound of a click, out of ammunition, helplessly watching her husband be murdered, her daughter be raped or murdered, and the enraged men coming for her. Wow. Wow. That's, Does the AR click? You know, when that firing pin comes home and doesn't hit a bullet, sure does. Yeah. Yeah. Of course it clicks. Yeah. When the firearm goes click instead of bang, yep, it definitely clicks. Yep. In another case, an AR-15 was used by a young man in Oklahoma to defend himself from 3 masked armed intruders, all wearing black. The intruders selected this home because the family had money and expensive property and belongings, and the criminals had previously burglarized an apartment on the property. The 3 intruders broke through the rear glass door before, to their surprise, they were shot by the home intruder. When 7 armed and masked intruders went to a home at 4 in the morning, Garand goes ping, which is, roughly the equivalent, but yeah. When 7 intruders and masked intruders went to the home at 4 a.m., burst through the front door and fired a gun, the occupants of the home, one armed with an AR-15, fired over 30 rounds to stop the attacker. An AR-15 was used to stop a knife attack in an apartment building in Illinois. Dave Thomas grabbed his AR-15, explaining, "It's just a bigger gun. I think a little bit more than an intimidation factor definitely played part in him actually stopping. No shots were fired." Thomas also said, "The AR-15 is my weapon of choice for home protection. It's light. It's maneuverable." An AR-15 style rifle was used by a homeowner across the street from a mass shooter in Sutherland Springs, Texas. The defender shot and injured the mass shooter, who then dropped the assault weapon and fled. An AR-15 was used to stop an intruder in Pennsylvania. A criminal also already awaiting trial for aggravated assault in another incident forced his way onto the couple's apartment. One of the apartment dwellers was able to retrieve an AR-15 and defend, who disregarded warnings to stop. Prohibited features are good for home defense. The evidence shows one reason the popularity of the modern rifle is it makes a good weapon for self-defense of the home. The AR-15 in particular is an easy firearm to shoot accurately, and generally easier to fire accurately than a handgun. The AR-15 is light in weight and has good ergonomics, and suitable for people of all statutes and varying lengths of strength. When burglars break and enter, a homeowner with a modern rifle has 30 rounds at the ready, assuming a standard magazine is used. I like how he calls it a standard magazine. Good for him. Standard size magazines are ubiquitous. With psychological stress of waking to the noise of home invaders, one may need many rounds to overcome the difficulty of aiming in the dark at multiple attackers making furtive movements. The adjustable stock can be quickly set for one's arm length. The pistol grip gives a homeowner a secure hold with one hand, while the other hand holds a telephone or spare magazine. A flash suppressor prevents nighttime defender from being blinded by their own muzzle flash. It may also hide the location from an attacker. A barrel shroud serves as a way to attach a flashlight or laser pointer. The straight line design of the AR-15 is easier to shoot accurately because muzzle rise is reduced. It's heavier, it's bigger. Yeah. The gas piston design reduces recoil, so young or old may have better control. The light weight makes it easier to hold, while the shorter length 30 makes it more maneuverable through the doorway. How soon until this language reaches a marketing ad? That's the real question. How soon until this language makes its way to a marketing ad? This is good shit, man. Stephanie says if she needs 10 rounds, she's doing it wrong. Stephanie, not everyone is as badass as you, girl. Okay? Not everyone is as badass as you. Some of us mere mortals may need more. On an AR-15 rifle, a telescoping scope is capable of adjusting to between 3 and 6 different lengths. This enables a rifle stock to quickly and properly adjust to the fit of the user, which is particularly beneficial to persons of smaller stature. Plaintiff Wendy Hoffman, a firearms trainer, says this telescoping scope is preferred for training women or younger shooters. She owns a featureless firearm, which she accomplished by removing the features, but Hoffman would have preferred a standard one with ergonomic features, such as a pistol grip or foregrip to control the firearm. In addition, she preferred to use and train other women shooters with this stock, which can accommodate smaller shooters. Why am I getting a boner just thinking about it? All these women together with their telescoping stocks. Badass. The telescoping stock also makes a single weapon useful for different members of a household. A folding stock, though makes a firearm more portable, does not turn a semi-automatic rifle into a common instrument of crime, since it does not make a rifle easily concealable for most criminal activities, making a folding stock almost irrelevant. And the AR-15 is easily separated into 2 halves by pulling out 2 pins, as was demonstrated during the hearings by a deputy U.S. Marshal. That must have been a fun hearing. 2 halves of a 30-inch rifle are more concealable than a 30-inch rifle with an adjustable stock. A pistol is far more concealable than either and often used in crime. Stephanie says so when he says gun goes click, did anyone hear the cow goes moo? That's funny. Very good. $5 from Storm Crow 900. Lord Almighty. Uncivil, call the moral police. The judge is taking way too dirty. The language is pure unadulterated sex. I know what I'm talking about, right? This is just like, ugh. This is good, man. This is good. Hide your kids, hide your wife, man. This is uncivil law after dark. We're gonna have to restrict this under the First Amendment, not the Second, right? We're gonna have to start talking about whether this passes the test for obscenity. Which, hey, with the people being beaten this badly, yeah, that's a good one. That's a good legal question that may never have been asked before. Can we restrict access to this federal court opinion because it reaches the level of obscenity from the beating? Questions we never thought we'd ask before. Good shit. California's reasons for banning. What is the reason for continuing to ban these modern firearms? The state is concerned about the configuration of particular arms that have proven to be the most lethal in mass shooting. The Attorney General says the state is concerned with rapidly firing accurate rifles. As the state attorney explained during the first day of testimony, I'll tell you, the state has demonstrated in this case and in our pleadings, the states are concerned about the particular configurations of certain center-fire automatic rifles with detachable magazines, but fire those rounds rapidly and maintain accuracy. This is of concern. So there are other concerns, but that's what California is concerned about. The Attorney General's view of rapid-fire accuracy as danger to be outlawed. Accuracy is very important for self-defense because the civilian is accountable for every round he fires. If he misses an attacker, he'll hit something he did not intend, which may include an innocent bystander. The state does not dispute the importance of accuracy for self-defense. Does the state want rifles that are less accurate? No and yes. The state wants rifles that are less accurate during rapid firing because rapid firing, it's claimed, correlates with criminal use. And there's no need of rapid firing for self-defense according to the Attorney General. The Attorney General argues the features prohibited by law are characteristic of military weapons, and military weapons are designed to be accurate with rapid firing. Perhaps, but the civilian rifle has design features similar to military rifles, does not detract from its constitutional protection or self-defense. Stephanie says don't bring her firearm skills into this. You're the one who brought your firearm skills into this, Stephanie. I'm not the one bringing it into it. You're the one. You say don't bring your firearm skills into this. You're the one who said if you need 10 rounds, you're doing it wrong. What are you talking about? The exception for the rule for civilian defense is a weapon's ability to fire full automatic. The ability to fire full automatic is above what distinguishes an M16 from an AR-15. But an M16 was modified to allow for burst and single fire capabilities because it was recognized that firing in full automatic is less accurate and wastes ammunition. And that's where the mantra that the AR-15 almost as fast as the M16 fails. Because the M16 proves fast but inaccurate shooting in full automatic mode when accuracy is needed, the M16 has the option of a slower mode for firing like the AR-15. The home defending victims described earlier need rapidly fire their modern rifles and need them to fire accurately. For home defense, accuracy is always important, not only for hitting the attacker, but also for hitting only the attacker. Emmanuel Capelson testifies, accuracy is very important for self-defense because unlike a criminal using a firearm, the civilian or the police officer, either one is accountable for every round they fire. And any round that misses the attacker who's attacking, if it doesn't hit what they intended, then by definition it hit something it didn't intend. That may hurt somebody else. So the accomplishment of good level is paramount in self-defense training. The AR-15 is an accurate gun and can be fired repeatedly if need be, more rapidly than a bolt action or lever action rifle. One video in evidence is particularly interesting. In this short video, 2 AR-15 type rifles were fired repeatedly and reloaded with detachable magazines at a target in daylight. One rifle has all the prohibited features prohibited by law. The other was featureless. The results were similar. Each rifle fired at approximately the same speed and accuracy. Any difference was hardly noticeable. Of course, the video was staged for a purpose, but clearly demonstrates a little difference in operation for lawful and unlawful. The presence or absence of a flash suppressor makes no difference in day. It may had the demonstration been done at night. The person demonstrating modestly describes himself as modestly experienced. $5 from Mandalore Wise. Enhances the capability for militia readiness. Ouch. Reminding the citizens are militia. You got it, babe. Absolutely. The video demonstration raises question. The state says modern rifles without prohibited features work fine. Since the features are cosmetic, there's no burn on the rights. The plaintiffs say that modern rifles without the features are just as lethal, and therefore pointless. The plaintiffs say that what the state labels cosmetic features have no effect, and they're not really, or apologize, I misread that. The plaintiffs say that what the state labels combat features have no effect, they're not really combat features. The ban fails to achieve its purpose of prohibiting a more lethal firearm. The state says the features are not needed for lawful use. The plaintiffs say the features make no difference in unlawful use. Even if they made a difference, the plaintiffs say the notion improvements made the firearms better and safer for lawful use makes them comparably better for unlawful use simply leads to the absurdity that firearms may never be improved because the harm a more accurate firearm in a criminal's hand will always justify a ban. So it would always justify guns not being improved. Isaac Castillo gives me $5 to say I approve of your right to use 10 plus rounds. Scary rifles too. You got it, man. The difference is the featureless rifle is more cumbersome for the surprised homeowner who, unlike the intruder, may not be as ready to wield his or her firearm. In the end, the court finds that prohibited features do not change the AR-15's rifle from a benign weapon into an incredibly effective killing machine. Another commonly espoused myth is the caliber of the center-fire semi-automatic weapons are more lethal. In fact, the evidence proves otherwise. The usual ammunition for an AR, the .223, is designed to cause wounding much more so than death. Dr. McGillis testified that this round was NATO's choice to inflict non-lethal wounds. He explained that using the .556 round, which is the .223, designed for wounding rather than killing, furthered a military goal of reducing the enemy force by diverting healthy enemy soldiers to be cared for, carrying its wounded soldiers. Hyperbole aside, AR-15 ammunition is designed to make the AR-15 a wounding machine rather than killing machine. The disproportionate bromide, and apparently we've got a correction in here. We've got a correction that's been left in with tracking changes. So we're changing our language here a little bit. The Attorney General stresses the notion that modern rifles are disproportionately used in crime. It seems like it could be true, but not supported by evidence. More importantly, disproportionately is not a constitutionality test. Heller and McDonald demonstrate the opposite is true. The court struck down bans on handguns in District of Columbia at a time when handguns were used disproportionately. By comparison, modern rifles are not used in crime nearly as often as handguns. Matthew says, I love how no one ever mentions in these people who want firearms to protect themselves are not protected by police unless police choose to protect them. That's right, Matt. That's right. I don't know if he's going to get there. I hope he does mention it, because that would just add the cherry to this increasing parfait. But yeah, the police have no duty to protect you, as we well know. So that'd be nice to add. We're on page 44. We're almost halfway there. If used by criminals could justify a ban, it would amount to something called like a disfavored heckler's veto. We might call it the criminal's veto. Cute. Just as like a heckler's veto wrongly punishes a person for speaking their ideas, California's ban punishes a person who chooses modern rifles for home defense. In other words, if modern rifles are misused in crime, even disproportionately, the government must deal with these wrongful acts directly, and may not deal with the problem by suppressing the rights of law-abiding to have modern rifles. Thus, disproportionality is not a valid constitutional concern. Common ownership by law-abiding is the test. Moreover, there's little evidence that modern rifles are used disproportionately. The Attorney General cites a 1994 Congressional House report. The House report actually said that assault weapons were a growing menace to society of proportion to their numbers rather than out of proportion to their numbers. Perhaps the report was published with scrivener's error. Oh, that's just, oh my God. Oh my God, no. Oh, what an insult to the Attorney General. That's such a backhanded insult. Oh, that's such a backhanded insult to the Attorney General. And I'm not sure that, that's so backhanded. Because the Attorney General has been saying, these are used disproportionately. And he cites this House report. And the judge then says, well, actually, the House report says that they're used in proportion to it. And then he adds this line of maybe the House report is simply making a scrivener's error. In other words, maybe that's a typo. Maybe the House really meant disproportionate because that's the way you're reading it. Oh, burn. Maybe you know about this secret scrivener's error that no one else knows because that's not what they really meant to write. It was just a typo. Oh, so much burn. Oh. Regardless, a single citation to a 27-year-old report cannot be said to support California's conclusion. There's no evidence that California's legislature relied on this report when it passed its ban, or later when it adopted the feature-based ban. There's no evidence the California legislature conducted its own study on whether modern rifles were being used disproportionately. There's no evidence the California legislature relied on studies from other states. There's no evidence that was making a sensitive policy judgment. There is, however, evidence at the time of the federal ban assault weapons were rarely used in crime. Even today, most national estimates suggest assault weapons are used in crime less than 7% of the time. To sell the disproportionate bromide, the Attorney General also cites its expert, but its expert does not express an opinion about modern rifle use in general crime. Instead, he opines that modern rifles are used disproportionately in what he calls gun massacres, not crime in general. And the expert defines a gun massacre as a shooting event resulting in at least 6 deaths where at least one assault weapon was discharged. Well, that's an interesting trick. That's a very, very interesting trick. Assault weapons are used disproportionately in gun massacres. You know how I know that? Because under my definition of gun massacre, an assault weapon has to be used. So, yeah, assault weapons are used very disproportionately, almost like they're used 100% of the time. I wonder why assault weapons are used in 100% of gun massacres. No other expert witness, sociologist, economics, or government agency defines a mass shooting this way. The definition almost creates a tautology. Yes, not so much almost as does, because, yeah, assault weapons are used in assault weapon-related assault weapons. The Attorney General takes another shot at this by citing another expert. It is not convincing. Like the other expert, this expert does not opine about general crime use. This expert opines more narrowly that modern rifles are used disproportionately in mass shootings. He says, as some other people have noted, assault weapons with large capacity magazines are disproportionately used in mass shootings. This does not help. The study dramatically undercuts the whole trope of assault weapons supposedly being used in crime. So the study you cite, yeah, in fact, the study finds quite the opposite to be true. So even the experts can't read. In its 2004 report, this report surveyed national data and found the estimates consistently show assault weapons are used in a small fraction of gun crimes, and most surveyed evidence on actual use of assault weapons suggests offenders rarely use assault weapons in crime. That does tend to suggest the opposite of disproportionate, yes. It also notes something that others tend to overlook. This report notes that many of the assault weapons used in crime, when they're used, are pistols rather than rifles. He explains, he notes also the majority of assault weapons used in crimes are assault pistols, rather than assault rifles, by definition of 3-to-1. Please don't ask me what an assault pistol is. I'm not sure anyone knows. Anyone who has any ideas on an assault pistol, leave a comment. The study concludes, while surveys suggest ownership and, to a lesser extent, use of assault weapons may be fairly common among some subset of offenders, the overwhelming weight of evidence suggests, no. The conclusions comport with ATF tracking data. Your own experts can't read. As in their presence of mass shooting, even this report explained the highest correlation is with the presence of large capacity magazines as opposed to assault weapons themselves. In the 2020 study, it notes, in summary, growing evidence suggests large capacity magazine restrictions reduce mass shootings are more potent than assault weapon restrictions. Nonetheless, the evidence is not yet firm enough to draw a definitive conclusion. Recall that to pass intermediate scrutiny, the assault weapons ban must have been designed to address a real-world harm and alleviate the harm in some sort of material way. The evidence so far provides the harm of assault weapon being used in a mass shooting is an infinitesimally rare event. More people have died. Oh my God. Wow. Okay. More people have died from the COVID-19 vaccine than mass shootings in California. Wow. Wow. More people have died from the COVID-19 vaccine than have died in mass shootings in California. Do you need to be nervous? No, you don't need to be nervous. The death rate for the vaccine is roughly 1 in a million. California has 20 million residents. I don't know about the demographics. So it's somewhere around 20, give or take. But that's still more people that have died from these events in California in the relevant time period. So no, you don't have to be worried. You don't have to be worried. But you should be more worried than you should be about mass shootings, apparently. Where was I? I lost my page. Hold on. All right, I found it again. Even if mass shooting from an assault rifle is a real harm, the evidence also shows the assault weapon ban prohibits features, has not alleviated the harm in any way. Perhaps recognizing the infirmity, the Attorney General attempts to draw attention away from the statute's small aim and maintain citizens do not need more than 2.2 shots for self-defense. So the constitutional version is mostly hypothetical. So let's talk about the 2.2 shot thing. Yeah. 5 shots from Ricardo Ospinilla since the stream just got demonetized. Yes, thank you, Ricardo, for supporting the channel financially. Thank you to everyone who supports the channel financially. It helps the channel grow. It helps me conduct new explorations for the channel, find new materials I wouldn't be otherwise able to do. Helped fund me go to this CrimeCon convention. Your super charts and donations in no small way pays for me the ability to do stuff like that. And whether or not it ultimately materializes in anything, the money that you guys help to provide helps me to go do new things. It's going to help me go to a convention in Vegas next month where it's going to be a bunch of independent creators, and I'm going to be able to try to learn some things from them that might help the channel. So I'm trying to use your funds that you're providing to help make the channel grow, and it really appreciate it. Thank you. And I wouldn't be able to do it without your help because I just wouldn't be able to afford it financially. So I really appreciate it. So if you want to support the channel, it's really appreciated. Thank you. $5 from I'm bored 742. More people died last year from objects inserted to their back doors. I believe it. Isaac Costello gives me $5. Says, what about my accost weapon, my freedom of speech? Isn't that what's next banned after my scary rifle? Given the way things are going, man, don't talk about speech bans too lightly. You know they might come. $4.99 for Mandy Amos, chipping in. Thank you very much. Thank you. I appreciate it. The Attorney General offers the old saw that large capacity magazines and accurate repeated firings are the only things needed by mass shooters. The story goes that for self-defense citizens, a citizen needs only 2.2 rounds. It is a myth. Take the case of an 80-year-old woman faced with a home invader who began attacking and stabbing her 75-year-old husband. Based 80-year-old woman about to come to the rescue. $50 from S. Blazer. Thank you very much for your very generous super chat. It is very appreciated. When the intruder attacked her husband with a knife, she shot the intruder. According to neighbors, she emptied the gun. When there's only a single intruder, 2.2 shots may not be enough. When there are multiple attempts, it's self-evident 2.2 shots will not be enough. Where did this myth originate? According to a 2018 study from a professor, evidence introduced by the Attorney General. There's no national or state data that captures information on shots fired in gun attacks. Attempting to fill this data with his own study, he reports the study finds that 20 to 28% of victims were wounded in incidents involving greater than 10 shots, most of which seems to be involved in high-capacity semi-automatics. The 2.2 shot notion comes from the state experts, Lucy Allen. Allen is an expert in economics and statistics. Unlike Kopler, who is an academic, who is a scholar undertaking peer-reviewed studies for the advancement of our understanding. Ooh. So unlike Kopler, who's an actual academic, Allen was hired specifically to conduct research for this litigation. Her study is not peer-reviewed. Her study cannot be tested because she's not disclosed her data. Her study cannot be replicated. In fact, the formula used to select 200 stories for her study is incomprehensible. Worse, the entire concept is suspect because it attempts to study an average defensive use based not on police reports, but on events in news media and others lacking detail, all while acknowledging that many events may not be reported. Allen did ask the state for police reports, but did not receive them. Allen testified the first thing they did was ask whether police reports were available. Here are the details. Allen claims that she's determined the average number of rounds fired by an individual in defensive gun use. To find that average, she says she conducted a word search with a database of news articles maintained by a news aggregator called Factiva. Factiva is a commercial database behind a paywall. She also conducted search of stories published by the NRA, Institute for Legislative Action, in their magazine conducted between 2011 and 2017. From those searches, she or a member of her team coded each story and arrived at the conclusion that on average, 2.2 shots were fired in defensive gun use, and 2.1 shots were fired if the defensive gun use was in the home. Her methodology with this database is incomprehensible. For the Factiva database of 70 million news stories, her word search returned 35,000 words. From there, she somehow selects 200 stories of defensive gun use in the home and set out to analyze these events. It's unclear how these stories were selected or what members of her team selected the stories to analyze. She describes selecting 200 stories out of a sub-collection of 4,800 stories by reviewing 1,400 stories. Where did the 4,800 stories come from? Her methodology cannot be duplicated, but here it is. Using a random number generator, a random sample of 200 stories was selected for each calendar year, yielding 1,400 stories in total. These 1,400 stories were reviewed to identify those stories that were relevant to the analysis, including self-defense with a firearm in or near the home. The methodology yielded a random selection of 200 news stories describing incidents of self-defense with a firearm in the home out of a population of approximately 4,800 stories. Thus, we found out of over 70 million news stories aggregated by Factiva, approximately 4,800 stories were on incidents of self-defense within the home. We analyzed 200 of those stories. It's a mystery how these 4,800 stories were determined, and we got some more corrections here from Base Judge who wants to make sure every word and period is perfect. More corrections. It's a mystery how 4,800 stories were determined in the universe of reports. In the deposition, she's not asked about these stories. Allen also fails to provide copies of the 200 stories she analyzed, or the mythical 4,800 stories. There is no list. There's no way to check her analysis or her math or try to reproduce her results, nor did she try. Allen's calculations also introduce other curiosity to arrive at her average of 2.2 shots. She includes in those events where no shots were fired. This has the obvious effect of bringing the overall number of shots needed down. She testifies she never calculated the average number of shots fired only in events where shots were fired, but agrees that whatever the average is, it would be greater than 2.2 because all the events where no shot were fired were removed from the equation. One would expect Allen's choice to include a 0 for no-shot events to be significant because 16% of events were no-shot events, according to Allen's data. For California-only events, 32% of shots were no shots. So she included 32% of events where no shots were fired to determine the average number of shots. For a study that set out to provide the number of shots required to defend one home with a firearm, the effect of the statistical manipulation is significant. Base Judge is adding some language because he'd like to rag on the report a little bit more now. He has some additional thoughts he'd like to add to his 94 pages. His 94 pages were not nearly enough. And he has some additional thoughts he'd like to add to his opinion. So he's got some additional thoughts he wants to add and some corrections. What if, for example, a study sought to measure the benefit of airbags in car accidents but include both accidents where an airbag deployed as well as where they did not? This result would surely show airbags made muted differences. The results erroneously diminished by the multitude of minor accidents in which airbags did not deploy and no one sustained injury. But when airbags do deploy, this surely provides a benefit. The impact of the benefit would be lost in this hypothetical study, drowned out by minor paint scratches and fender benders. Allen's study suffers from the same flaw. By including the number of events in which no shots were fired in calculation of an average, Allen's studies inaccurately reduces the average number of shots. Base judge needs to add some more words. To compound the problem, Allen used an imputed number of shots fired when a media report says shots were fired but did not report a number. This imputed number was averaged in, but Allen did not know and could not guess the number she used. Okay. Allen also used something called the Armed Citizens Database. The database is problematic because it's not really a database, but a list of magazine stories. First, the database compilers made no attempt to record all events or statistically represent the events. Allen has no direct knowledge of how the editorial decisions are made for including or excluding a story. She deduced only the stories with successful outcomes are published. One can only guess whether unsuccessful decisions include similar numbers of shots. Allen does not know how many stories are not published or not included. Like the Factiva collection, 736 incidents in the Armed Citizen Database were analyzed, but no list of incidents has been placed in evidence. As she acknowledged in her declaration, the NRA ILA Armed Citizens Database is not compiled scientifically. Allen's 2.2 or 2.1 shot averages are suspect for other reasons. The whole statistical exercise is based on news reporting rather than police reports. A database of news articles lacks indicia of accuracy. Well, when I've read as many news articles about gun incidents as you have, I think we can all testify that news articles relating to guns are not usually accurate. So, yeah. The professor observed there exists no database of defensive gun use or number of shots fired, but there are surely large numbers of these events. According to 15 national polls conducted by non-law enforcement agencies, there may be somewhere between 760,000 defensive uses to 3.6 million. Even Activity's fact search apparently identified 33,000 news stories, despite likelihood that many events go unreported, and may are reported to the police or not reported to news media. On the other side, a fully loaded modern rifle is surely a powerful psychological deterrent. Simply brandishing a weapon may cause an intruder to flee precisely because it appears to be dangerous and loaded. It's difficult to imagine It's difficult to imagine the same psychological effect on a home invader or two invaders from brandishing a two-shot Derringer. It's a reasonable inference the visual threat presented by a homeowner holding a rifle with a large magazine makes it an effective deterrent, all without firing a shot. All considered, Allen's opinion is entitled to little weight and fails the scientific method. Ooh. Okay, this headline, this headline, or this introduction alone tells me we're in a good time. We're in for a good time, children. Right? We're in for a good time, children. Here's the headline. You don't need more than 2.2 shots, and you don't need seatbelts or smoke detectors. I know we're in for a good time, kids. That's how the judge has started this section, with the introduction of you don't need more than 2.2 shots, and you don't need seatbelts or smoke detectors. I think we're in for a good time. $5 from Mandela Wise. Why does it sound like the judge owns a Derringer? Not sure he does or not, but it's hilarious either way. The Attorney General remonstrates that whenever a precise or average number is extraordinarily relevant because it shows the burden on the core right is minimal. It may be minimal much of the time. A law that bans seatbelts or smoke detectors would impose a minimal burden much of the time. One could drive 100,000 miles without needing seatbelts. But when unexpected collision occurs, seatbelts are really needed. One might live 100 years without needing a smoke detector, but when fire starts in the middle of the night, a smoke detector is really needed. A person may not need more than 2-point shots to defend themselves in an average situation, yet sometimes more than 2.2, sometimes much more are needed. That's just so much burn. $50 from Beric Merck. Thank you so much for the donation. Yeah, you don't need 2.2 shots. And you don't need that smoke detector because, that almost all the time we're living in a mostly peaceful, fire-free, crash-free life, right? Yeah. I want to extend an invitation to Benitez, see if I can get him on the channel. Let's see if I can get a federal judge to appear on Uncivil Law. That'd be good. Would you like to appear on a show where I just praise you endlessly? Federal judge. That could be fun. According to the United States Department of Justice, it's estimated that 3.7 million burglaries occur each year in the United States. A household member is present during approximately 1 million of those burglaries. Of these million household members present in their homes when burglaries occur, approximately 266,000 end up victims of a violent crime. 7,700 women are raped in their own homes. Each of the million burglaries each year when a household member is present is potentially a circumstance for defensive gun use. Unfortunately, for 266,560 homeowners, either no firearm was in hand or was not enough to prevent a violent attack. It begs the question, are lives of home invasion victims worth less than the lives of mass shooting victims? For some reason, for some citizens, a modern rifle is a first choice to prepare for home defense when this year's 3.7 million burglaries take place. For the future, 266,560 new victims of violent crime, a modern rifle may be a thing they regret not having. So the state here is concerned about configuration of particular arms that have been proven to be the most lethal in mass shooting situations, and that's what the evidence shows. Allen opines that a correlation between modern rifles and mass shootings. The specter of a mass shooting with modern rifle is really the driving force behind this prohibition. On cue, Allen uses her private database of news articles to identify correlation between mass shootings and modern rifles. As of December 2019, Allen identifies 161 mass shootings. In her previous case, she identified 109. In the previous case, she identified 96. In New Jersey case, she identified 83. In a Maryland case, she identified 69. And New York, 66. One might guess because the numbers keep changing because mass events keep happening. More recent events can account for 13 of these cases in the current tally, but there's something else odd going on with the counting. By comparing her 2009 declaration, in this case, to a 2000 declaration in a different case, many unexplained changes are evident. The numbers are changing for reasons that are unclear. 16 events have been removed. 54 new cases were added. Of the 54 new cases, 13 occurred in 2019 after the declaration was signed. Oddly, 41 new cases have been added from databases as far back as 1982. Allen's declaration is silent about these 41 cases. No one can blame Allen too much for her changing tally of mass shootings. The problem is disagreements over the definition of mass shooting, combined with a lack of a reliable database maintained by a disinterested organization or governmental entity. Indeed, these reliable collections of shooting stories are generally not based on police reports, but rather claim details from after the fact, sometimes sensationalized news reporting, lacking access to crime scenes and based on random bystander perception. Professor Kravas counts 103 incidents since 1980. As mentioned, he uses a few metric restrictions for this use: gun massacres. He defines gun massacres as events with 6 or more victims, instead of the more commonly accepted number of 4. He does not explain why 6 in his studies. Demonstrating another problem with the data, his count does not match Allen's count even where it should agree. For example, one would expect all of Kravas' 6 events would be on Allen's 4 events. Yet they're not. From more than recent decade, Kravas lists 10 events that inexplicably do not appear on Allen's list. And to the unreliability of this declaration, Kravas also includes a shooting with an assault weapon in California after the passage of the act that does not appear on the list. And Kravas omit events from before the act in California with an assault weapon that do appear on the list. Because of unconventional aspects of the approach, little weight is given to this testimony. With disagreement and uncertainty about what mass shootings are and how many have occurred, the Attorney General turns to national statistics. But the evidence is not what he thinks. Two hours in, man. We're 2 hours in. We're on page 59 of 94. 2 hours in. We're not done yet. We're not done yet. We have much more to go. Please like the video. Please become a member. Hit the join button. Follow the link. Subscribe. All that YouTube-y stuff. Do all the YouTube-y things, please. All right. The national experience. Analyzing the list of 161 national events, Allen finds that 78% of the shootings did not involve an assault weapon. Put differently, only 22% did involve an assault weapon. The opinion comports with other evidence in the record. Professor Guras reports even less frequency of assault weapons in mass shootings. Guras says, contrary to popular belief, assault rifles were not the predominant type of weapon used in this crime. In fact, according to a recent study, handguns are the most common type. Rifles are only used in about 8% of mass shootings. That may come as a surprise to the public, that's countlessly told assault weapons are often used in mass shootings. From Allen's list of mass shooting events, it's reported in California there have been 25 mass shootings over the approximately 40 years. How well has the ban worked? Before the ban, twice in a decade, an assault weapon was used. On average, since the ban, twice in a decade, an assault weapon has been used. The assault weapon ban has had no effect. California's experiment is a failure. Well, yeah, I mean, that's before, twice a decade, after, twice a decade. It's had no effect. The experiment has been a failure. Failure. To summarize, $25 or $20 from Juan. Thank you for going over this opinion. I'll have to go over the rest of the content later. Stay blessed. I am staying blessed, man. No problem. To summarize, the average rate of mass shootings with assault weapons in California has not changed in 30 years. Moreover, for all mass shootings, assault weapons are only used 8.25% of the time, 10% of the time, or 22% of the time, depending who you ask. In every California mass shooting, even with assault weapons, the shooter brought multiple weapons. The professor puts mass shootings and modern rifle ban in perspective. He concludes it's important to note mass shooting fatalities are often a small percentage of overall murders. Even if a certain type of gun control are found to eliminate mass shootings, which assault weapon bans do not, the overall murder rate would decline a very small amount. Moreover, perspective is important. Contrary to public misinformation, mass shooting events are rare. In contrast, as stated previously, there are 3.7 million burglaries per year in the years 2003 to 2007. 266,000 people suffered a violent victimization. 23,000 or 9% of those suffered a serious injury, and approximately 7,000 were raped. During that year, there was less than one mass shooting with an assault weapon per year. According to Allen's list, the total list of persons killed or injured during all mass shooting events with an assault weapon during the years of 2003 to 2007 was 38. Had laws been in place to prevent acquisition of assault weapons from 2003 to 2007, 38 people may have been spared being shot with an assault weapon, although they may have been shot with a non-assault weapon. In contrast, during those same years, 7,700 women may not have been raped, and 266,560 homeowners may not have suffered a violent victimization during burglary of their home. Imagine calculating the figures over 30 years. Of course, many victims do not choose to own a modern rifle, and though victimized once, some may choose not to arm themselves again. The Constitution does not force citizens to arm themselves, but they do provide the liberty and freedom to do so. Today, assault weapons ban trenches on the rights of 266,560 citizens protect themselves from violent assault in their homes by criminalizing acquisition and possession of a common firearm they may deem best for defense, balanced against a possible reduced risk of shooting 38 people is lopsided. Assault weapon wounds, are they worse? The Attorney General argues that victims of assault weapons generally suffer more extensively and more numerous wounds, resulting in a higher morbidity and mortality, relying on testimony from other people. These people opine that assault weapons enable the shooter to fire more rounds rapidly in a given period with greater accuracy, including increasing the likelihood that more individuals be shot and suffer multiple injuries, making it more likely individuals suffer complication. He concludes while all weapons pose risk, assault weapons, even those with large magazines, pose a far greater risk to the public from a medical standpoint than a non-assault firearm. First, as the video demonstrates, the injury from firearms like the AR-15, which are banned as assault weapons, are no different than those that are common and lawfully owned. Second, there's no difference in lethality or accuracy or firing capability between a featureless AR-15 and one with features. Yeah, this does seem to be a point that somehow gets missed. Like, the same bullet is coming out of the gun, right? So it's going to be equally lethal either way. The features don't make the bullet go faster or farther, So, This doctor has impressive credentials. He's practiced emergency medicine for 50 years. For 24 years, he served in active duty in the Navy, including combat experience. The doctor also currently serves as a sworn reserve officer. According to the doctor, the biggest flaw with the declaration is he does not explain why the supposedly extreme wounds generated from an intermediate cartridge such as .223, fired from a California assault weapon, bearing the features and characteristics set forth, would present a greater wound profile than a wound suffered from the same same round fired from a non-assault weapon. Right, because it's the same round. The doctor does not explain how the winds generated from these weapons using the same round and same length would be qualitatively different from a Mini 14 firing the exact same round. Good question. Without first knowing what ammunition is used, one can only generally characterize a bullet wound. According to the doctor, looking at a gunshot wound, one is able to determine during treatment of the wound that was either, relatively speaking, low velocity or high velocity. You couldn't tell the difference between a 9mm and a .45 injury just from looking at the injury. You couldn't tell the difference between a .556 or a .762 simply by looking at the injury. You could tell one came from a higher velocity or a low velocity. It's not widely known, but rounds used in assault rifles are lower velocity than traditional military and hunting rounds. According to the doctor, intermediate cartridges used in assault rifles pose significantly less kinetic energy than traditional military cartridges, as well as rifle cartridges designed for hunting. Therefore, an intermediate rifle cartridge can't produce a more serious injury than a full power cartridge, which has been designed for the military or hunting. The cosmetic of the firearm, whether it has a flash suppressor, makes no difference. A .556 fired from a bolt-action rifle, one of which I owned. It's old wood stock, bolt-action .223. That cartridge-bulge combination is going to produce the same energy and the same wounding potential, and the point of impact is the same at the same distance as an assault rifle would. Yep. You don't have to be a doctor to know that. Yeah, surely. As an emergency room physician, the doctor says, for me to talk about a wound, I'd have to know the cartridge, bullet, barrel, distance, and point of impact. It's going to make a lot of difference if someone strikes the shoulder, strikes them in the middle of the forehead. So I'd have to know those things. It's not going to make any difference to me if the patient came from a bolt-action .223 or if it came from an AR-15. Not information I need to know to treat this. So to summarize the medical evidence, the severity of a gunshot depends on many things, perhaps the importance of the cartridge used and the velocity of the bullet. Both achieve much higher velocity from long barrels than short barrels. A modern rifle like an AR-15 typically uses a lower powder cartridge than military or hunting. While there are exceptions, for the purpose of state regulation, it doesn't matter. This is confirmed by the Attorney General's own evidence. As set forth by Dr. D. Maio in the authoritative work Gun Wounds, the wounds from an assault rifle are less severe than hunting. Dr. DeMaio explains one of the common fallacies about assault rifles is the wounds they produce are more severe due to the ordinary center fire. In fact, the wounds are less severe than all hunting rifles. The severity of the wound is determined by kinetic energy lost by the bullet in the body. The intermediate cartridge used in assault rifles significantly less energy than a regular centerfire cartridge designed for hunting. In addition, since most ammunition in these weapons is loaded with full metal jacket, the wound is even less severe than might be imagined. All right, how about stray bullets hitting the wall and hitting bystanders? I'm running out of drinks. I only brought 3 beers to the table, and I'm running out. Some say a bullet fired from an AR-15 in self-defense could penetrate a wall and strike a bystander. The court is unaware of any evidence such event has ever been reported. One thing is clear: there's no evidence that home defenders using AR-15s hitting bystanders with stray bullets through walls is a common problem. A stray bullet fired from self-defense might penetrate a wall is an argument in favor of using a more accurate firearm. There's evidence that AR-15 rifles are both accurately and easy to fire. There's mixed evidence about where AR-15s are more or less likely than a handgun to penetrate the walls of a typical home. For example, one expert testified in a deposition. They had done demonstrations with various rounds fired at walls of drywall and lumber. He testified a wall penetrating capability of .223 round depends more on the construction of the projectile than on the particular firearm. Another study the ground 55 grain 223 round, one commonly used in modern rifles, penetrates a wall less than a common 40 Smith & Wesson handgun round and less than a 12-gauge shotgun slug. The study found that 55 grain hollow point 223 has less penetration than any of the other ammunition tested. Based on results of this testing, there appears to be no basis for concern regarding overpenetration of 223 round. In fact, it seems even safer than a 40 Smith & Wesson handgun. Well, actually, there's a myth corrected for me. I would not have thought that. So, hey, even I can learn something about firearms and how they're used. So, yeah, there you go. The idea of a stray bullet fired from a modern rifle will penetrate the wall, also hit a bystander, will depend largely on particular ammo and whether the home is crowded or rural. Depend less on the firearm and not at all whether the firearm has prohibited features. The Attorney General introduced testimony from another witness worth noting. Blake Graham is Assistant Director of California Department of Justice Bureau of Firearms. He worked as a firearms investigator. He offers both witness and expert testimony. Graham says the most common feature of prohibited assault rifles is a pistol grip, and the second most common are telescoping scope and flash suppressors. There's no evidence to the contrary. Graham's opinions on ammunition is less convincing. For example, he says that centerfire rifles generally use rounds that are associated with increased lethality, while true, only half so. As the different expert explained, for rifles and pistols, almost all centerfire ammo is more lethal than almost all other types of ammo, which is rimfire. $5 from the dentist. I'm surprised I haven't heard people claim since he owns guns he's biased. It's almost like they're offended by the ruling without reading it. I guarantee you most people offended by this have not read it. They didn't get past the Swiss Army knife in sentence 1. Graham says .223 caliber and .762 ammunition used with assault rifles. This is true. He says these rounds will typically defeat normal bullet-resistant armor used by law enforcement. Again, true, but only half so. A doctor who serves as a police department armorer says that all rifle rounds from any rifle will defeat a normal police body armor. Typical body armor is expected to resist only lower caliber ammo fired from a handgun. Ian Graham acknowledges a bullet fired from a handgun travel at slower muzzle velocity than bullets fired from a rifle. The slower a bullet is, the less likely to pierce body armor. Conversely, faster, more likely. The feature-based prohibition says nothing about ammo or bullet velocities. In fact, one might argue that prohibiting rifles shorter than 16, the statute encourages them to use longer barrels, which are actually more lethal. That's hilarious. So by banning rifles that are shorter than 16 inches, because the bullet velocity is determined by how much powder it can burn, which is determined in part by how long the barrel is, you're actually determining that these will be, you're actually encouraging them to have longer barrels, which will result in a higher round speed. That's funny. Graham also opines on magazines. However, his opinions there lack precision. For example, he opines a detachable magazine allows a shooter to rapidly exchange a depleted magazine with a fully loaded one, enabling a shooter to fire a number of rounds near constantly. It's an overgeneralization. A trained and composed shooter with a gun and 2 75-round magazines may well be able to fire many rounds nearly consistently. An untrained homeowner awoken at night having a pistol and surging adrenaline may not be able to fire as many rounds. Graham also opines that a person interested in doing harm will often pair assault weapons and multiple magazines to maximize lethality. Graham offers little support for his supposition. Sociologists know little about the motivation of mass shooters except that they generally quest for notoriety and infamy. In fact, are influenced by seamless, endless reporting when a tragedy does occur. Little, if any, reporting occurs when an intruder is shot or deterred by defensive gun use. True that. Graham says he's researched several mass shootings, but 2 shootings took place before he worked for the state. 13 shootings occurred beyond the boundaries of California. 2 shootings took place beyond the northern hemisphere. Of 7 shootings that did occur within California, Graham does not say he personally investigated these cases. Graham does not say how many shots were fired. Though he surely could access them, Graham does not offer the police reports. In short, much of Graham's testimony ventures beyond his expertise and experience. Simply put, the evidence indicates gun bans are ineffective at reducing gun crimes. The plaintiff's expert, John Lott, for the cause, man. John Lott's done a lot of great work for the gun cause. Some not so great work, to be quite honest, but he's done a lot of great work. John Lott is, for those of you who don't know, is a major academic whose work has been used by gun rights people. So, yeah, John Lott's work being cited does not surprise me at all. John Lott has opined. I've met John Lott, by the way, a couple times. You know, he's a very unassuming guy. I'll just name drop all the people I've met, right? Opines all credible evidence showing that assault weapons bans have little to no effect in reducing mass shootings. Professor Coper, on assessment of 10-year federal assault weapons ban, concluded although the ban has been successful in reducing crimes, any benefit from the reduction are likely been outweighed by steady or rising use of non-banned semi-automatics with large capacity magazines, which are used in crime much more frequently than assault weapons. Benefits from hard evidence that bans are effective. The Attorney General radios in for backups from other courts of appeal. Okay, so the Attorney General, things are not going well for the Attorney General of California, so he wants to go to the many, many other courts of appeal who have opined on this. So now Judge Benitez basically has to beat up on the other courts of appeal. Judge Benitez is kicking ass and taking names. Yeah, and Belzer did donate $50. I think I acknowledged that earlier. If I didn't, I'll acknowledge it again because I do want to make sure the people that donate get their acknowledgement. I appreciate everyone who's donating, trying to keep up with it. All right, let's continue on. Where are we? Page 70 of 94, kind of the home stretch, sort of, kind of. Ugh. All right, I'm almost out of beer. The Attorney General's position is that the assault weapons ban does not severely burden Second Amendment rights. After all, assault weapons are supposedly uncommon, unusually dangerous, though other guns available, and 2.2 shots are needed for self-defense, so any gun will do. Better have a state citizen armed with micro-stamping Saturday night specials than an accurate AR-15. Since the constitutional burden is mild, 80-minute scrutiny will be satisfied. How can one argue with every other federal circuit? How can one argue with every other federal circuit court to have considered assault weapon restrictions? Well, Judge Benitez here has set himself a task. Judge Benitez is now about to set himself out the task of arguing with like half a dozen courts of appeal. Okay, let's go kick some ass. In the past, Second Amendment cases were wrongly decided following a majority of circuits down the wrong path. This is what happened in 1996 when the Ninth Circuit erroneously decided the Second Amendment does not confer private citizens a right to possess a firearm. When the court said we follow our sister circuits in holding the Second Amendment is a right held by states and does not protect a possession of weapon by the private citizenry. It has happened the first time the Ninth Circuit considered the assault weapons ban. The plaintiffs argue the Second Amendment guarantees an individual right to keep and acquire firearms. Crookshank and Presser both make clear the Second Amendment binds only the national government. In this view, we join the Seventh Circuit. Happened the last time the Ninth Circuit upheld the ban. Long dormant view of the Second Amendment, widely accepted by federal courts. Before Heller, hundreds of judges erroneously overread Miller, as Heller itself pointed out. Thus, with heightened circumspection, it's time to see what can be learned from his decisions. The Attorney General first cites Wilson versus Cook County, 2019. Wilson was not decided on facts or evidence. Wilson was decided at the outset because an earlier Seventh Circuit's decision was controlling. End of analysis. Friedman, however, did look at facts because it applied intermediate scrutiny, as the Attorney General citation suggests. Friedman asked the question, instead of trying to decide what level of scrutiny applies and how it works, we think better to ask whether regulation bans weapons that were common at the time of ratification, or of some reasonable relationship to the preservation or efficiency of a well-regulated militia, and whether law-abiding citizens retain adequate means. That's a reasonable question, but Friedman did not rely on the answer. Friedman ultimately upheld municipal assault weapon bans because it was a permissible experiment and good for community psyche. If a ban on semi-automatic guns and large capacity magazines reduces perceived risk from mass shooting and makes the public feel safer, that's a substantial benefit. It is worth pointing, however, that along the way, Friedman made some observations the court made today that perhaps 9% of the nation's firearms owners have assault weapons. Assault weapons generally are chambered for small rounds, suggesting they're less dangerous. Friedman also observed, as does this court, that assault weapons can work well for self-defense. True enough, assault weapons can be beneficial for self-defense because they're lighter than many rifles and less dangerous to shoot. Householders too frightened or infirm to aim carefully may wield them more efficiently. The dissent echoes this point about assault weapons. Their ability to project large amounts of force accurately is exactly what they're attractive. While most persons do not require extraordinary means, some do. Although it was a close call, it upheld a ban. Fair enough, but the Seventh Circuit was not using intermediate scrutiny. Burn. Burn. The Attorney General next cites First Circuit, 2019. In that decision, the District Court and First Circuit sidestepped answering the question of commonality while noting that nearly 5 million people owned at least one assault weapon. The case was decided on summary judgment rather than trial. In some respects, the record evidence is different. The record states that assault weapons can be fired through walls and risk the lives of those nearby. By contrast, according to the evidence in this case, handgun rounds are more likely, and the ban is not based on calibers. More importantly, the other case notes that there's no evidence in the case about even a single example of an assault weapon used for home defense. The missing evidence in that case is presented in this case. So apparently the First Circuit was unable to find any evidence of an assault weapon being used in home defense. This guy's over to the rescue. I've got you covered. As mentioned earlier, AR-15 was used by pregnant women to defend her family. Finally, that court unpersuasively rejected the main argument that forbidden assault weapons were ideal for domestic defense by pronouncing the assertion too facial by half without explaining what it meant. So, there's a footnote. The expression too facial by half is uncommon in American English and appears only one other time in a U.S. case. It is not found in the corpus of contemporary American English. We literally have no idea what the hell you meant when you wrote that. Burn. Burn. That's okay. How about the Fourth Circuit? Off to the rescue. The Seventh Circuit didn't help, and the First Circuit didn't help, but that's okay. Let's give the Fourth Circuit a try. The Attorney General next cites this Fourth Circuit. This went in its own direction and concluded assault weapons are so much like M16 machine guns they lay outside the ambit of the Second Amendment. In that case, the court wrote, "We conclude the banned assault weapons are not protected by the Second Amendment." As the dissent put it, our court today has adopted an ad hoc analysis that excludes a weapon from the Second Amendment protection if it appears to be like an M16 or most useful for military service. Under this approach, it's irrelevant that a firearm may have been commonly possessed and widely accepted as legitimate for hundreds of years. The conclusion is unpersuasive. An AR-15 rifle may be like an M16 machine gun in many ways, but the singular major difference is also the legally determinative one. In fact, when the Supreme Court issued Heller and commented, it may be objected that if weapons are most useful in military service, M16 rifles and the like may be banned, knowing there's a difference between M16 and AR-15s, and that the AR-15 is most popular owned. Why wouldn't they have chosen to mention the M16 and not the AR-15? Good question. So when the Supreme Court said, hey, how about M16s? Why didn't they mention AR-15? The answer seems obvious. An M16 is fully automatic, suitable for military. The AR-15 is not! Exclamation point. In the alternative, the Fourth Circuit found that state regulations did not impose a severe burden and applied intermediate scrutiny. The burden was not severe, according to the Fourth Circuit, because citizens were free to protect themselves with a plethora of other firearms. Once again, this is at odds with Heller. The Fourth Circuit also deemed the burden not severe because, like summary judgment, in the other case, there was scant evidence of record that banned assault weapons were even suitable for protection. Once again, we're off to the rescue here because we've got it. Whatever's missing, that's not the issue. Fourth Circuit, go away. So, hey, First Circuit, Seventh Circuit, Fourth Circuit, hey, how about some Second Circuit life? Let's try some of that Second Circuit life and see if that helps it at all. Man. The Attorney General next cite New York State Pistol Rifle Association versus Tacoma. That decision applied intermediate scrutiny after citing New York and Connecticut laws imposed a burden that was not severe. The Second Circuit also relied heavily on jurisprudence of firearms alternatives. In fact, the single reason given for finding a burden was not severe was because the notion of numerous alternatives remain. Curiously, although the decision relied on it, the Second Circuit's decision was not about a ban on assault weapons or any particular firearm. Instead, it highlights the opposite situation. The court said that because 922A3 does not substantially burden the right to keep and bear arms, it does nothing to keep someone from purchasing a firearm in their home state, which is presumptively the convenient place to buy anything. The decision unsurprisingly decided merely a ban on gun shows at county-owned firearms did not substantially burden the right. The case found that fire gun shown ban left open other avenues for buying the firearm. Unsurprisingly held that 922K is constitutional because it bans only firearms with obliterated serial numbers. The jurisprudence of firearms alternatives has surely drifted far away from Heller. Heller said in 2018, so we're going right back to the Supreme Court, right? Hey, every court of appeals, like ever. Hey, every court of appeals ever. You've been circle jerking each other for a while? Have you guys read Heller? Maybe you guys forgot. Let me help you out on the reading of the Heller thing. Heller said in 2008, it is no answer to say permissible ban the possession of handguns so long as other possession is allowed. Yeah, so this case steps slightly away and says it's permissible to ban firearms without serial numbers because any other gun is permissible. It says permissible to ban firearm gun shows because any other gun, the gun can be purchased anywhere. It says permissible to ban guns bought outside because it may be purchased within the state. Then New York State took a long jump from Heller and banned assault rifles as permissible because alternative guns remained. Which is unlike any of those things, right? Saying you can buy guns that are legal and you can buy them in legal places, but you can't buy them. Those are two different things. Today, the Attorney General goes beyond this and suggests that intermediate scrutiny should permit a class-wide ban on extremely popular assault rifles, assault shotguns, and assault handguns, whatever the fuck that is, in addition to an existing ban on buying any handgun not found in the shrinking list of the handgun roster because some alternatives remain. This goes too far. District of Columbia versus Heller, Part 2, Electric Boogaloo. The last circuit decision cited by the Attorney General is Heller 2. To decide on summary judgment, Heller 2 upheld prohibitions on assault rifles, finding the burden to be insubstantial. Heller 2 accepted as fact that assault rifles are common, but on summary judgment, the court could not be certain whether the weapons are commonly used or useful for self-defense. The Heller 2 court explained, although we cannot be confident that prohibitions impinge on a core right protected by a Second Amendment, or reasonably certain that prohibitions do not impose a substantial burden on that right, because plaintiffs present hardly any evidence that semi-automatic rifles are well suited to or preferred for the purpose of self-defense. Since District of Columbia residents were still permitted to possess handguns or non-automatic long guns, Heller 2 agreed with other cases that the burden was no bigger. One problem with relying on Heller 2 is that California statutes go much further. Our law criminalizes possession of certain semi-automatic pistols. Even Heller 2 conceded a ban like that may be unconstitutional. To sum it up, the Seventh Circuit said it was bound by Freeman and it didn't apply the right standard. In the First Circuit, lacked the record. In the Fourth Circuit, it decided the rifle was outside the protection of the based on scant evidence. In the D.C. Circuit, that where assault weapons were useful despite a record. Even so, they said, and the Second Circuit completely rejected the notion. None of these decisions fit this case. None of these decisions can fit this case. Hey, Seventh Circuit, First Circuit, Second Circuit, Fourth Circuit, D.C. Circuit. None of that makes any sense to me. None of that makes any sense over me. This judge is so pimped, man. Wild West pimp style. That's what I have to say about this judge. Wild West pimp style, man. He's destroying everyone. He just destroyed half the circuits in the federal system. The Central District of California has rejected a similar challenge on the assault weapon ban because, unlike some other cases, decided on summary judgment that AR-15s are virtually indistinguishable. Okay, so the Central District of California came to some conclusion. That conclusion would be unsupported by the trial record here, unless one accepts the overgeneralization that all semi-automatics are virtually indistinguishable from all automatic sample guns. Decide alternatively, intermediate scrutiny should apply because the alternative guns were canard. Canard. The alternative guns canard. Nice. The other decision also unfairly discounts the evidence that 30% of modern rifle purchases are made for self-defense by placing too much emphasis on purchase for recreational target shooting. Both purposes are lawful and the ban bans both. It's not convincing to say that stifling is one need. To have a tool chosen 30% is not a severe burden. As I destroy my, brother, judge in this, would sister be right in this? No, probably brother's probably closer. But as I destroy my brother court within the same circuit, Yeah. In any event, an AR-15 is not like an M16 because one's fully automatic and one's not. This is testimony in this case. An AR-15 may fire rounds at speeds up to 5 to 7 rounds per second. Each round requires a figure pull. The AR-15 has no minimum rate of fire. Consequently, an AR-15 may be fired slowly or up to a hypothetical maximum of 300 to 400, assuming no pulse for reloading, which itself is purely hypothetical and unrealistic. Compare this to a modern machine gun that can fire 1,000 rounds, allowing the shooter to kill dozens of people within seconds. Federal laws codified this difference for decades. The Supreme Court has recognized the difference. Non-circuitly most recently recognized the difference. We agree with the reasoning of our sister circuits that machine guns are dangerous and unusual. Semi-automatic pistols are at fire at rapid rate. Hill or Norm MacDonald found them to be beyond the Second Amendment. In fact, almost not all negative aspects of these prohibited rifles, like faster firing, are shared with Second Amendment protected semi-automatic firearms. Like the Strom Mini 14 and Springfield Armory 1911. For example, the Attorney General asserts detachable magazines enhance the ability of semi-automatic firearms to fire large rounds quickly by eliminating the need to reload. This is true of the Mini 14 and the venerable 1911 pistol. The Attorney General says the ability to attach a detachable magazine provides the soldier with fairly large ammunition supply and ability to reload. The same is true of the 1911 pistol. The Attorney General says except the ability to attach a detachable magazine renders a semi-automatic weapon capable of killing or wounding more people in a shorter amount of time. This is true for the Mini 14 and 1911. The Attorney General claims the use of large capacity magazine-equipped firearms in mass shootings results in a substantially greater number of firearms, fatalities, and injuries than mass shootings not involved. Same would be true of the Mini 14 or 1911. This is illustrated in the Virginia Tech mass shooting where 2 semi-automatic pistols were used to kill 42 people. The Attorney General says a pistol grip enables a shooter to maintain accuracy during rapid fire. The same is true of a 1911. The Attorney General says that folding or telescoping scope enhances portability. A 1911 pistol is much more portable. The Attorney General argues a flash suppressor enables concealability. The same would be true of a fixed flash suppressor of a Mini 14 or 1911. The Attorney General sneers that assault weapons have a military pedigree. The 1911 also has a military pedigree. That's a very, very nice berm. That's a very, very nice berm. Yeah, that's a very, very nice berm. Assault weapons have a military pedigree. So does the 1911. Why is it called the 1911 again? Oh, yeah, that's right. That's right. I remember. $5 from Isaac Costello. Judge Swagger. Electric Boogaloo and feckless rulings. That's right. The point is, most of what the Attorney General says are dangerous features on prohibited modern rifles are also features on Second Amendment protected rifles, or semi-automatic pistols. The Ruger Mini 14 is not banned, but capable of shooting the same ammunition, the same speed, with the same large capacity magazine. Perhaps different treatment is explained by the fact that Mini 14 looks like an old rifle with a wooden stock. At bottom, guns are dangerous. Guns with removable magazines are dangerous. Guns that can fire 30 rounds without reloading are dangerous for 30 rounds worth of uninterrupted time. The Attorney General conflates the increased danger of high capacity with the innate dangerousness of any semi-automatic firearm and then rests the conflation to justify class prohibition. The prohibited rifles shoot further than pistols, but not as far as other rifles. Beyond that, prohibited firearms share most of the same characteristics as permissible pistols like the 1911 and the Glock 17. The AR-15 is virtually indistinguishable from a semi-automatic pistol in function. It's virtually indistinguishable from the M16, but only in appearance. Oof. Oof. Page 81. Page 81. Come on, guys. Let's support the channel. Let's give me some comments of encouragement. How about that? Let's just give me some comments of encouragement. You don't even have to donate anything. How about just some comments of encouragement saying, yeah, Uncivil Law, you go, Uncivil Law, you're doing great. You can make it. You can make it through the remainder of these pages. We're loving this opinion. Just some notes of encouragement to keep me going. We've been doing this 2.5 hours. And we still got like 13 pages to go. Thank you. Thank you. The Attorney General does not address or acknowledge whether the ban also imposes a burden on the Second Amendment right to own a firearm that is the ideal weapon for use in the militia. If a modern rifle is the ideal weapon, which it is according to the testimony of General Youngman, then ban forces a choice of less than ideal weapon for militia use. That may not be a severe burden today when the need for militia is improbable. One could say the same thing about an improbable need for insurance. Ooh. The point is, neither the Attorney General nor the current court decisions address the level of scrutiny to employ when a regulation burns the Second Amendment. Thank you for all the encouragement. I really do appreciate it. Thank you. Mandalorian Y says, what is your blood alcohol level? Not that high, actually, because I've only had 3 Guinnesses, and Guinness are very low alcohol, so my blood alcohol level is very, very low. Thank you very, very much. Okay. The point is, neither the Attorney General nor the current court decisions address the level of scrutiny. The court assumes that for intermediate scrutiny, the fit of a total ban is judged by its application of all aspects of exercising the right. Home defense, militia use, sporting competitions, hunting, target practice, and other lawful use. The concept of a citizen's militia, as protected by the Second Amendment, is an informal assembly of able-bodied, ordinary citizens acting in concert for the security of our nation. Citizens' militia is a safeguard against tyranny. The militia comprises all males physically capable of acting in concert for the common defense. There are at least 2 reasons why the militia is thought to be necessary to the security of this free country. First, it's useful in repelling invasion. Secondly, when the able-bodied men of a nation are trained in arms and organized, they're better able to resist tyranny. For service in citizens' militia, one is expected to bring for action a commonly used firearm such as a gun used in self-defense at home or for hunting game. Ordinarily, when called to militia service, able-bodied men were expected to be able to appear bringing arms supplied themselves and other common use. Weapons used by militia and weapons used in defense of a person at home were one and the same. In this case, the evidence overwhelmingly supports that AR-15 is ideal for both citizens, militia, and a state-organized militia. Quite apart from practicality, as peacekeeping only for home defense, a modern rifle can be useful for war. In fact, it's ideal for militia service. Major General Alan Youngman, United States Army, testified credibly about the usefulness for militia for an AR-15 platform. He describes 3 tiers of militia service. General Youngman testified that a state may or may not have a statute authorizing a state defense force. California does have a state defense force of 1,000 members. During World War II, California used a state defense force much larger than 1,000 to secure critical infrastructure. For this type of use, an AR-15 would be absolutely the perfect weapon for the individual member of that force to be equipped with for a variety of missions, to include infrastructure protection and the like. The AR-15 pattern of rifle, with its highly standardized and interchangeable component parts, is a firearm not just well-suited, but ideal for militia service. The AR-15 use of standardized magazines and common ammunition and reliable, low cost, and lightweight serves the same purposes sought to be achieved by the drafting of the founding era's militia acts. Furthermore, the modularity and standardization of the AR-15, its ubiquity, commonality, and common widespread ownership in common ammunition sizes, such as .223 and .556, and the interchangeability of parts, including magazines, makes it ideal. For example, says General Youngman, AR-15s can interchange trigger mechanisms, bolt and locking components, barrels, magazines, buttstocks, optical sights, bayonets, and other assorted furniture with few specialized tools. Further, even if 2 AR-15s might be set for vastly different uses, for example, long range versus short range, the majority of wearable components remain interchangeable. The parts interchangeable of the AR-15 platforms means any militia field armorer with a short list of components could service the militia's standard rifle, as well as special purpose ammunition. It means virtually any standard rifle could be equipped by the armor for a special purpose. Most certainly in the best interest of the militia, for militiamen to have their arms serviceable in a consistent, economical, and efficient way, as afforded by the virtual unique platform of the AR-15. Moreover, for the militia, the low cost is an ideal factor because we'd be asking individuals to acquire and maintain their own in the absence of being issued one. The AR-15 is very affordable for the average citizen who might be a member of the militia. The light weight of the AR-15 makes it ideal for militia use because it would accommodate a wide variety of physically conditioned individuals, as well as smaller stature, male and female. The pistol grip below the AR-15 makes it more useful for militia. Without a pistol grip, it would be much more difficult to train loading, unloading, and clearing. The pistol grip also enhances accuracy because it puts the trigger finger in the proper alignment, helps to control the firearm. While folding stock offers no particular advantage, according to Youngman, a telescoping scope offers the ability to fit the rifle to an individual regardless of stature, as well as the ability to accommodate body armor. A grenade launcher may have some utility for militia use because it can fire tear gas or flares. A flash suppressor will be useful at night because, in Youngman's quote, you don't go blind after the first round. A detachable magazine is absolutely essential for militia use. Youngman explains because in the militia setting, you need the ability to change magazines expeditiously, rather than have to manually reload rounds into the firearm. A firearm that has the overall length of 30 inches would be useful in militia service because of increased municipality for urban operations. The overall military is going in the direction of a 16-inch barrel rather than the longer, older barrels. Youngman's testimony is uncontroverted. Youngman is very well qualified to opine about the usefulness of the AR-15 for militia. He served in the regular army and the reserves. He served as the Kentucky Adjutant General commanding the state's National Guard. He's a firearms trainer and armorer. He was a member of the bar and worked as a prosecutor. Nice. His opinion that the AR-15 is an ideal firearm for use in the militia is unequivocal and uncontested. All prohibited features, most are important for militia use. Heller recognized that militia members traditionally report for duty carrying the sort of lawful weapons that are possessed at the home. The Second Amendment therefore protects such a weapon as a class regardless of any particular weapon suitability for military use. Owning much to the commonality of ownership as well as features, the AR-15 is a modern rifle that's suitable for the militia. I'm going to go out and buy an AR-15 just because I can. I mean, I swear to this is inspiring me. It's like if you didn't own one before, you know what I mean? Because of a weapon of light warfare, it's commonly owned, commonly trained, with common characteristics and common interchange parts, it's protected for militia use by the Second Amendment. California statutes impose criminal penalties for making and possessing, by ordinary citizens who would make up a militia, a firearm that's well suited for militia service. It is the exact opposite of a statute with a reasonable fit and places the most severe burden on those who are able to be part of citizen militia and unable and ultimately burden all the people of the state and nation. Some courts have coined the AR-15 a weapon of war. Some courts have concluded that because the AR-15 is most useful in the military, it's not protected by the Second Amendment. Some courts have reasoned that the M16 is most useful in the military and thus can be banned, and the AR-15 is like it, so it can also be banned. But Miller has held that precisely this type of firearm, a firearm that has a reasonable relation to the military, is protected by the Second Amendment. It's a principle Heller grasped. The holding of Miller is not only consistent with, but positively suggests the Second Amendment confers an individual right to keep and bear arms, though only those arms that have some reasonable relationship to the preservation and efficiency of a militia. The Attorney General does not agree that militia clause can put brakes on the state's power to ban arms that are ideal for militia use, but the militia clause informs the full understanding of the right. The militia clause helps us understand the contours of the Second Amendment. After Heller, the prefatory clause may not dictate the content of the Second Amendment right, but neither is it irrelevant. 44 or 50 states have a Second Amendment analog, and most have a clause referring to militia and the right to defend self and state. The point was made by this court before in Rode. The Supreme Court also recognized that the Second Amendment guarantees individual firearms that have some reasonable relationship to preservation or efficiency of the militia. Miller implies that possession by law-abiding citizens of a weapon and ammunition commonly owned that could be part of the ordinary military equipment for the militia and would contribute is protected by the Second Amendment. Heller and Miller are consistent. Heller took the already expansive zone of protection for weapons that could be used by a militia and focused on the core of the firearms for defending the home. It is enough to note, as we've observed, that American people have considered the handgun to be a quintessential self-defense weapon. For whatever reason, handguns are the most popular weapon choice for Americans for self-defense in the home. As McDonald put it in Heller, we've recognized that codification of this right was prompted by fear the federal government would disarm and thus disable the militia. But we've rejected the suggestion the right was only valued only as a means of preserving the militia. On the contrary, we've stressed the right was valued because possession of firearms was thought to be essential for self-defense. Self-defense is a central component of the right itself. The court has underscored these 2 points. 1, the Second Amendment extends to common modern firearms useful for the home. 2, modern firearms, beyond just those useful in warfare, are protected. Major Youngman did not address the utility of other major rifles, such as the semi-automatic AK for militia use. The evidence is clear, however, the AR-15 type rifle bears reasonable relationship to preservation and efficiency as effectiveness of the modern militia, is therefore categorically a Second Amendment protected firearm. Before the court, there is convincing and unrebutted testimony that the versatile AR-15 type rifle is a perfect firearm for a citizen to bring to militia service. A law that bans an AR-15 for militia readiness is not a reasonable fit for protecting a Second Amendment right to keep and bear arms for a militia. It has been argued that citizens with nothing more than modern rifles will have no chance against an army with tanks and missiles. But someone forgot to tell Fidel Castro, who with an initial force of 20 to 80 armed men with M1 carbines walked into power in Havana in spite of Cuba's military forces armed with tanks, planes, and a navy. Someone forgot to tell Ho Chi Minh, who said those who have rifles will use their rifles, those who have swords will use their swords, those who have no swords will use their spades, hoes, and sticks, and eventually defeated both the French and U.S. military. Someone forgot to tell the Taliban and his Iraqi insurgents, citizens' militias are not irrelevant. Wow. That's yeah. So it's like, yeah, even in modern warfare, you know, the U.S. military has taken note that, you know, some of our opposition is using these weapons with some effectiveness. So I wouldn't go so far as to say it's irrelevant. Yeah, there's that. For this reason, state statutes ought to specifically preserve the right and ability of law-abiding citizens to acquire these arms, but no purposeful criminal acquisition and possession of the rifle, as California does, particularly because it would be useful in modern warfare, as contrary to the purpose of the Second Amendment, and therefore displays no degree of fit. The Attorney General objects by saying the government must be allowed a reasonable opportunity to experiment with solutions to admittedly serious problems. How long does the experiment have to go on, and what are the limits? California's had more than a reasonable opportunity to experiment. In the face of this failed experiment, California persists with the experiment. The facts found at trial are that California statute has not solved the problems of mass shooting or the shootings of police officers despite 40 years of testing. We have to be free to experiment, but how's that experiment been going, yo? What do you have to show for your 40 years of Second Amendment infringement? How's that been going? Not that great. The Attorney General maintains that under intermediate scrutiny, courts afford substantial deference to predictive judgment of the legislature. Deference makes sense when new problems arise and new solutions are needed. At some point, it becomes clear whether a solution is correct or not. At this point, in this case, it's clear the legislature's predictions were incorrect. The demonstrably incorrect predictions are no longer entitled to deference. Ooh. So, yeah, the legislature might be entitled to some predictive deference, but that was so long ago in the far, far away, and you are now incorrect, so all your deference is gone. Wow. Nice. I am pretty sure, Azeroth, the U.S. military does use M16s in addition to M4s. The Attorney General retreats to the principle that even when the record contains conflicting legislative evidence, intermediate scrutiny allows the government to select among reasonable alternatives in policy decisions. The legislative record of the assault weapon ban makes it clear that respecting a citizen's constitutional right was not among the alternatives. It was not a consideration at all. Likewise, a citizen's right to be prepared for armed militia service is not an alternative, was not a considered alternative. The California legislature did not choose among reasonable alternatives, as long as the alternatives include protecting a space for a citizen's Second Amendment rights. The Attorney General argues that deferential review is particularly appropriate here because the legislature is far better equipped than the judiciary to make sensitive policy judgment within constitutional limits concerning dangers in carrying firearms and manages those risks. A legislature may be better equipped, but in the end, a legislature may also make those sensitive judgments and must make them within constitutional boundaries. The California legislature has made its judgment without protecting or considering individual Second Amendment rights. Therefore, its judgment is outside the limits and entitled to no deference. The end of the road is here. The assault weapons ban fails intermediate scrutiny because it lacks a reasonable fit. It is a continuing failed experiment which does not achieve the objectives of preventing mass shootings or attacks on law enforcement. The evidence suggests it has made no difference at all. Whether it's made a large difference is on the lives, where it has made a large difference is on the lives of numerous law-abiding citizens who would make, buy, and use these prohibited weapons for home defense and military readiness, but for the threat of severe criminal punishment. A reasonable fit would, at the very least, include a broad exception for home defense. A reasonable fit would, at the very least, also recognize an exception for maintaining the AR-15 type for military readiness. But today there are no such exceptions. The burn substantially protect the more activity is necessary to further the state's goals. The assault weapon ban certainly fails under the more demanding standard strict scrutiny. Narrowly tailoring using the least restrictive means under strict scrutiny would go much farther and include specific exceptions for a person to acquire and possess an assault weapon for home defense and other habitations, such as a motorhome, houseboat, camping tent, and hotel room, an exception for those who are unable to comfortably afford more than one firearm to bear an assault weapon everywhere firearms are not prohibited. Whoa. So he's going to the edge of the page. He's even talking about right to bear. This is how deep base Judge Benitez is, guys. He's even talking about right to bear. This is how deep he's going. He says that if strict scrutiny were a thing, then the law would have to be amended so that the concealed weapons or the concealed carry, open carry stuff, because California does technically issue permits, right? But it would have to include an exception for the impoverished who might only be able to afford an AR-15. And so they would have to be allowed to carry their AR-15 in public. Base Judge Benitez is calling for AR-15s to be able to be carried in the public in California by the poor. That's pretty based. Just throw that in there as a little ending, just in case you unclear about where my head's at. Yeah. Narrow tailoring would include a safe harbor provision for all home defense use, self-defense, and any non-self plays, hunting, sports, and all lawful use. Perhaps these are better experiments that can be tried by the state to reduce mass shootings. As stated previously, shooters seek notoriety in news coverage. Perhaps restraint in news coverage might be a novel approach. Perhaps better education for our children, or perhaps expansion of our mental health will be the answer. In the end, the Bill of Rights is not a list of suggestions. The Bill of Rights is not a list of suggestions for social balancing. The Bill of Rights prevents tyranny of the majority by taking away the rights of minority. When state nibbles on constitutional rights, who protects the minority? The federal courts. The Second Amendment protects any law-abiding citizen's right to choose to be armed to defend himself, his family, his home. At the same time, the Second Amendment protects a citizen's right to keep and bear arms to use should the militia be needed to fight invaders, terrorists, and tyrants. The Second Amendment is about America's freedom, the freedom to protect oneself, family, home, and homeland. California's assault weapon ban disrespects the freedom. Plaintiffs challenge California Penal Code and some other stuff. It's declared these statutes unconstitutionally infringe the Second Amendment rights of California citizens. These statutes and the penalty provisions as applied to assault weapons are hereby enjoined. You might not know it, but this case is about what should be a muscular constitutional right, and whether a state can force a gun policy choice that impinges on that right with a 30-year-old experiment. It should be an easy question and answer. Government is not free to impose its own new policy choices on American citizens where constitutional rights are concerned. As Hellers explained, the Second Amendment takes certain policy choices and removes them beyond the realm of permissible state action. California may certainly conceive of a policy that a modern rifle is dangerous in the hands of a criminal, and therefore it is in good public policy to keep modern rifles out of the hands of every citizen. The Second Amendment stands as a shield for government imposition of that policy. Oof. California might think certain choices are good, but the Bill of Rights has removed certain choices. California cannot make that choice. There is only one policy enshrined in the Bill of Rights. Guns and ammunition in the hands of criminals, tyrants, and terrorists are dangerous. Guns in the hands of law-abiding citizens are better. To give full life to the core of self-defense, every law-abiding citizen has a constitutionally protected right to keep and bear firearms commonly owned and kept for lawful purposes. In early America and today, the Second Amendment right of self-preservation permits a citizen to repel by force when the intervention of society in his behalf may be too late to prevent the injury. Then as now, the Second Amendment may be considered as a true paladin of liberty. Unfortunately, governments tend to restrict the right of self-defense. In most governments, it has been the study of rulers to confine that right within the narrowest limits possible. Fortunately, no legislature has constitutional authority to dictate to a good citizen that he or she may not acquire a modern popular gun for self-defense. $5 from LK. Understand where he's coming from. He's watched the Ninth Circuit uphold every gun restriction. I think Young was his last straw. This is him daring the Ninth. No, I don't think anyone is confused. I don't think anyone is confused here about where he's coming from. He's not only challenging the Ninth, but he's challenging the 1st, 2nd, 7th, 4th, and DC circuits, I think. Yeah. So he's basically challenged everyone. He is challenging everyone. He has done the biggest come at me, bro, maybe ever. He's challenging the Ninth Circuit. He's challenging another district court within his own court. He's challenging his other district court. He's challenging the Ninth Circuit, First Circuit, Second Circuit, Fourth Circuit, Seventh Circuit, DC Circuit. He's challenging freaking everybody. He has gone into the wind and tore open his shirt at the rain saying, let it come, let it come. Base Judge Benitez is based, man. He's not, yeah. I think he'd challenge everyone to a fight if they let him. The court does not lightly enjoin a state statute. However, while the court is mindful the government has a legitimate state interest in protecting the gun from gun violence, is equally mindful the Constitution remains as a shield. As Senator Edward Kennedy, the judiciary is, and often, the only protector of individual rights. That is the heart of our democracy. Quoting Senator Kennedy is a nice touch. Law-abiding citizens are imbued with an inalienable right to keep and bear modern firearms. JG says you hate the judge is mostly right. Yeah. Temporary stay. The Attorney General has asked for a stay of any injunction pending appeal. A party seeking a stay must establish they're likely to succeed, likely to suffer irreparable harm, amounts of equities ticks, and instance of public interest. Ninth Circuit has held likelihood of success per se is not an absolute requirement, and serious questions going to the merit can support issuance. Serious questions are substantial, difficult, and doubtful, and need not promote certainty of success. Because this case involves serious questions, a temporary stay is in the public interest. He's probably right. The declaration is stayed for 30 days, at which time he might seek appeal. After 30 days, the following takes effect. The defendant, attorney general, and his officers, agents, servants, employees, and attorneys, and those acting in concert participation, those duly sworn peace officers, and federal law enforcement who gain knowledge of this injunction are prohibited from enforcing a whole bunch of stuff, and the attorney general shall provide forthwith his personal service actual notice to all law enforcement who are responsible within 10 days that they can't do this. It's so ordered. Signed. Based. Judge Benitez. Well, it took 3 hours. It took 3 hours to get through 97 pages of decision. But I think it was worth our time. I think it was worth our time. Judge Roger Benitez is based. This is really good. Now, as I state what I stated at the beginning, because I stated this 3 hours ago, and I'm sure you all forgot, but yeah, of course this will be appealed, and the likelihood of it being overturned is pretty high, but I stand by the opinion. I stand by the opinion that the reasoning and thoughtfulness and map of the opinion is actually more important than the actual holding. So, because courts learn from other courts, and then every once in a while, someone comes along and basically like lays out something new, you know. It goes through work and lays out something new that courts can borrow from, right? Because courts learn from each other. It's evolutionary followed by, you know, bits of revolution, basically. Although this opinion, in terms of its holding, may not be long for the world, the reasoning and text of the opinion survives, right? It survives. So even if the Ninth Circuit, you know, goes the other way, which seems likely, this opinion serves as a basis for some other opinion in some other circuit, right? This serves as a map for some other judge to write an opinion and use this rationale or use these rationales, right? To borrow or steal, as the case may be. So whether this gets reversed or not is in some senses not as important as the fact it exists. The fact it exists is in some ways more important. And I stand by that opinion. Obviously, it would be nice if the opinion stays valid, right? We would like that. But if it's overruled, it still exists and serves as a roadmap for courts of appeal, for district courts, for the Supreme Court. It exists, and it influences attorneys. It influences the arguments they make, makes the arguments better. So this palpably moves the ball, in my view, regardless of what fate might ultimately befall this decision. So I think it's great no matter what happens. And the Ninth Circuit will, I'm sure, poo-poo it and say, guns are bad and all the rest of it, but it exists out there for someone to use as a model. So, And he's by no means the only one who's done this, by the way. There have been other people in other decisions and dissents who have done stuff like this, right? But he's materially adding. He's materially adding, and he's also consolidating. Like, not all this is strictly speaking his, but he's consolidating it all and putting it in a place that makes it accessible. And he's writing in a way that makes it accessible. He's building off the backs of giants like everyone else. But he's putting it in a way that makes it accessible for people. So it's really, really positive there. Really, really positive. So, yeah. So we'll see. It wouldn't be absurd, for example. It wouldn't be absurd for some of this language or some of these ideas to make it into amicus briefs that are being submitted to the Supreme Court right now from the New York pistol rifle case, or if the Supreme Court takes Young, right? It wouldn't be absurd for them to use this language, some of this language, to make its way into an amicus brief. It wouldn't be absurd for an attorney arguing the case to use some of these ideas as part of their argument. It wouldn't be absurd for the Supreme Court, to, when they're writing, to use ideas here as part of their writing. So whether or not, like, he's ever cited or not, as part of that, whether or not he's ever cited or not, he can influence the conversation. He can change the conversation in really, really powerful ways. So I really think it's important. So I think it was worth our time to read, because even if it gets overturned, which seems very likely, I think it has value beyond its ability to immediately influence the law. It sits there for someone to find someday in a very, very real way. So that's kind of what I think about all that. So I hope you enjoyed this time. I enjoyed this time. I appreciate you spending this marathon with me. It was a lot. My voice hurts a lot. Reading 94 pages of destruction, was a lot. I appreciate your time. If you haven't already done so, please remember to hit the subscribe button. Tell your friends. Share this video on Facebook. Share this video on Twitter. How about that? Do that for me. Share the channel. Go to Twitter or Facebook or whatever is your social media of choice and share this channel. Or share this video. Or whatever other video you want. How about go to social media and share this channel so that other people may discover this content. That'd be great. Or subscribe if you haven't done that already. Hit the notification bell if you haven't done it already. If you're not a member already, hit the link or hit the join button. Help support the channel financially so that I can continue to look for new ways to expand the channel and look for new ways and hopefully make this a full-time career. That'd be great. And all the rest of it. So I'm going to sign off for now. I hope all's well. Until later, my friends. Cheers. And goodbye.